Senate will come back to order. Senator from the 27th, you're on deck.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to House Bill 266 as amended by Amendment 1.
House Bill 266 by Representative Zanes, the 180th, and others, a bill to amend title and act to amend Article 2, Chapter 7, Title 48 of the Official Code of Georgia Annotated related to the imposition rate computation exemptions and credits for state income tax so as to exempt from state income tax income received as personal compensation for full-time duty and active military service in the United States and for other purposes. Mr. President, Senator Dawes on the 27th offered the following amendment number 1 to amend the House amendment to the Senate Committee substitute of House Bill 266 by striking 50 on line 92 and replacing it with 75. Mr. President, the House offered the following amendment to amend the Senate substitute to House Bill 266 by replacing all with certain on line 2 and for other purposes. Mr. President, that completes the order.
Is there objection? All right. Recognize the senator from 27.
There's no real objection.
What did I miss? What did I miss? Nothing. Okay. All right. All right, colleagues. House Bill 266 has had quite the journey. It started as Senate Bill 1, passed out of this chamber with significant bipartisan support. If you recall, this is the bill that eliminated the state income tax on military retirement income. The House has changed that on line 15 such that the first $65,000 of military retirement income will be tax-free. And they have introduced Section 2. Section 2 deals with a bill that we passed a few years ago here called the Less Crime Act. It allows taxpayers to donate money to a 501c3 that supports local law enforcement. It allows local law enforcement to use those tax dollars while giving a dollar-for-dollar tax credit to the taxpayer. What the House is doing here is allowing multiple local law enforcement agencies to share a single C3 to either save on startup or administrative costs or just for approval processes with the IRS. They are slightly expanding the uses to include pay for support staff in addition to officers, as well as some additional technology that they want to be able to purchase. They also reduced the percentage a corporation could donate from 75 to 50% of that corporation's income. A big driver of this program for local law enforcement has been corporations. So what I would like to do is go back to current law on the 75% on line 92, which is what the amendment does. We have agreement from the sponsor in the House of the original underlying bill, as well as the author of House Bill 266. So I'd like to move this amendment, make that one change, send it back to them for an agree, and get this done now both for our military veterans as well as local law enforcement agencies. Mr. President, I'm happy to answer any questions, and if there are none, I'll yield the well.
I have no questions.
I'll yield the well. Thank you.
Is there any other senator who wish to speak for or against the measure? Okay, the senator has moved that the Senate agree to the House amendment to House Bill 266 as amended. Is there objection? No objection. All those in favor of the motion will vote yea. All opposed, no. Secretary, unlock the machine. On the agree, the yeas are 52 and the nays are 0, and House Bill 266 passes. Senator from the 31st, for what purpose do you rise? Oh. Recognize Senator for the 3rd for a motion.
Mr. President, I move the Senate agree to the House substitute for SB 245.
Secretary, read the caption.
Senate Bill 245 by Senator Hodges III and others, a bill to be entitled an act to amend Code Section 19-7-3, the official code of Georgia annotated, related to actions by grandparents or other family members for visitation rights or intervention, revocation or amendment of visitation rights, and for other purposes. Mr. President, the House offers the following substitutes. Senate Bill 245, a bill to be entitled an act to amend Code Section 19-7-3, the official code of Georgia annotated, related to actions by grandparents or other family members for visitation rights or intervention, revocation or amendment of visitation rights, appointment of guardian ad litem, meditation, hearing, and notification to family members of child separation and events, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 3rd to speak to the motion, or you should speak to it. Or if you don't want to speak to it, it's fine too.
Thank you, Mr. President. Colleagues, Senate Bill 245 originated with us. It's a good bill. It's a good bill for grandparents and for families. It went to the House. They changed a little bit, but I can live, and I think we should live with what they sent us back. So I appreciate us approving this.
All right.
Thank
All
you.
those in favor of the motion to agree on Senate Bill 245, all those in favor will vote aye. All opposed, no. Secretary, unlock the machine. On the motion to agree on Senate Bill 245, the yeas are 52 and the nays are 0. Senator from the 43rd, for what purpose do you rise?
What's Jason district number? I'm sorry, I asked for unanimous consent to excuse the senator from the 35th.
35th?
Yes, sir.
All right. Without objection, the senator from the 35th is excused. Recognize the senator from the 31st for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to House Bill 551.
Senator from the 44th.
Thank you, Mr. President. I'd like to ask for unanimous consent to excuse the senator from the 22nd business inside the Capitol.
Without objection, the senator from the 22nd is excused. Secretary, read the caption.
House Bill 551 by Representative Ridley VI and others, a bill to be entitled an act to amend Title 40 of the OCGA related to motor vehicles and traffic so as to provide for conditions, procedures, and limitations for issuance of temporary operating permits for motor vehicles, to amend Code Section 43-47-8 of the OCGA related to license applications for used motor vehicle dealers and used motor vehicle dealer parts, and for other purposes. Mr. President, the House offers the following amendment to amend the Senate substitute to House Bill 551 by replacing line 9 with the following. The Department for certain violations to provide standards for the issuance of dealer master plates to authorize access to certain information with the state. By replacing line 11 with the following: for certain purposes, to revise and provide for definition, to provide for notice and hearings, to amend the code. By replacing lines 110 and 111 with the following: A, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 31st.
Thank you, Mr. President. House Bill 551, if you remember, is the TOPS bill. And we are grateful we had a amendment that came back to create a compromise between the Senate and the House. It basically adjusted the minimum amount of real estate, the minimum amount of cars a dealer must have for the TOPS, and softened the booting language in the bill. Very simple. And with that, Mr. President, I'll take any questions.
Recognize Senator from the 14th.
Thank you, Mr. President. Senator Yield.
I yield.
Senator, it's not true the towing industry reviewed this bill with legislative counsel and found the amendment doesn't do anything to affect the towing industry.
The senator from the 14th knows of what he speaks.
Thanks, Senator.
You're welcome.
From the 29th.
Does Senator yield?
Yes, to my friend the whip.
Thank you, Senator. Could you explain what softening of the booting language means?
So basically, one of the provisions in the bill is that it would eliminate and try and stop basically these companies that would monitor lots and look for people coming and going off of lots to basically kind of, in my words, play gotcha and then go and put a boot on their car if they go into a facility or establishment or restaurant, or like many of us have probably experienced at one point in time in our life.
Senator, further yield?
Yes, sir.
Senator, these lots you speak of, are these lots owned by government or owned by individuals?
I think it just totally depends. It's probably a little bit of everybody. Some are probably government owned.
So, Senator, further yield?
Sure.
Senator, if this lot is owned by a government entity, then wouldn't it be the responsibility of that government to regulate the use of any type of device, whether it's wreckers, boots, windshield screens, and other devices used to manage parking? And would it not be the responsibility of the private property owner to do the same?
Probably to an extent. I don't know that I would want my government tax dollars having to hire a monitor to look for somebody to go put a boot on their car. I mean, some of them will be there in the lot, collect money, show you where to go, insert your cash, your card to pay for your time there. But if we're spending money and contracts doing all these other things, I mean, I don't know if that really makes sense.
Senator, is it not true that I agree with you that if it's a government lot, we should not be wasting taxpayer dollars on that lot for this type of responsibilities? But if it is a private owned piece of property, then it would be up to the property owner, whether it be a convenience store, whether it be a hotel or anything else, to determine what type of actions going on their own property, whether it be booting windshield screens or towing of vehicles?
Yeah, probably so.
Thank you, Senator.
Senator,
Thank
can
you.
yield
Ask
now.
for a green vote. Thank you.
Anybody other senator wish to speak for or against the measure? All right, so the senator from the 31st asked for agree to a House amendment to the Senate substitute on HB 551. All those in favor will vote aye. All opposed, no. Secretary, unlock the machine. On the agree, the yeas are 50 and the nays are 3, and this bill has prevailed. Recognize the senator from the 50th. Been a very busy man today, Senator.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 40, amended by Amendment Number 1.
Senate Bill 40 by Senator Hatch of the 50th and others, bill between title and act to amend Article 14 of Chapter 1 of Title 10 of the Official Code of Georgia annotated related to secondary metals recyclers as to provide for applicability of the term, definition of the term used attached catalytic converters to said article, to remove the exception for used attached catalytic converters from the application of said article and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 40, a bill between title and act to amend Article 14 of Chapter 1 of Title 10 of the OCGA related to secondary metals recyclers so as to provide for the applicability of the definition of the term used attached catalytic converters to said article, to remove the exception for used attached catalytic converters from the application of said article, to provide for certain registration requirements for secondary metals recyclers and for other purposes. Mr. President, Senator Hatch of the 50th and others offered the following amendment number 1 to amend the House substitute to Senate Bill 40 by replacing lines 1 and 2 with the following: to amend Article 14 of Chapter 1 of Title 10 and Article 2 of Chapter 8 of Title 12 of the OCGA related to secondary metals recyclers and solid waste management, respectively, and for other purposes. Mr. President, that completes the order.
Senator, didn't we do something to this bill last year? We did? Well, come on down here and tell us about it.
Thank you, Mr. President. Senate Bill 40 is the catalytic converter bill. We passed it last year. It's the one that was stripped. So Senate Bill 40 is the bill we passed last year that was stripped in the House and replaced with judicial compensation. We brought it back through. We passed it out of here one time. It was sent over to the House. They added some language that included not just the Clean Air Act, but all federal regulations on catalytic converters. And this amendment that I'm bringing here, I'm bringing on behalf of the state's recycling industry. It aims to clarify existing law regarding waste from metal recycling. It makes clear that certain non-metallic byproducts of recycling that are taken to landfills are charged similarly to construction materials and inert waste. Happy to answer any questions.
You have one question. Senator from the 6th.
Thank you, Mr. President. Senator, do you yield?
I do, to my friend from the 6th.
Senator, what year did you get elected?
2020.
2020. And then sworn in 21?
21,
Is that
that's
correct? Right. Have you been trying to do this bill every year since you got here?
I have.
Are you wanting some pity votes at this point?
I'll take them any way I can get them, Mr. Chairman.
You'll have my pity vote.
I appreciate it.
Recognize the senator from the 29th.
Senator Yield,
I will.
Senator, do you know where the catalytic converter convention is held every summer?
I do not.
Would it be true then to say you have not attended recently?
I have not attended the catalytic converter convention, no.
Thank you, Senator.
Senator, do you even know where a Cadillac converter is located on an automobile?
I do. It's at right before the exhaust pipe. It's
All right, we're done with you.
Thank you, Mr. President. I yield the well.
Any other senator want to speak for or against the measure? Hearing none. The senator has moved that the Senate agree to the House substitute on SB 40 as amended by Amendment 1. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Senator from the 2nd, what purpose you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, is it not true that you may not know where your catalytic converter is, but you know when you don't have one?
It's very true, Senator. It's very true. Senator from the 48th, you're on deck. motion to agree. The yeas are 49, the nays are 4, and this motion has prevailed. Recognize the senator from the 48th.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 212.
Secretary, read the caption.
Senate Bill 212 by Senator Still, the 48th, and others, a bill to be entitled an act to amend Part 14 of Article 6, Chapter 2, Title 20 of the OCGA related to other educational programs under the Quality Basic Education Act so as to prohibit the disclosure of public student directory information to political candidates, campaign committees, political action committees, political organizations, or persons or groups acting on their behalf, to amend Article 15, Chapter 2, Title 21 of the OCGA related to miscellaneous offenses relative to elections and primaries, to amend and for other purposes. Mr. President, the House offers the following substitutes: Senate Bill 212, a bill to be entitled an act to amend Part 14, Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia annotated related to other educational programs under the Quality Basic Education Act so as to prohibit the disclosure of public student directory information to political candidates, campaign committees, political action committees, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 48th.
Thank you, Mr. President. Before I discuss Senate Bill 212, I'd like to just give a clarification to the senator from the 50th. The senator from the 8th was confused. I think you said Cadillac converter. Was that right? So if you could help him with some clarification on the pronunciation and spelling, that'd be helpful. Senate Bill 212, a little different topic than Cadillac converters, but we are talking about child data safety. There was a friendly amendment put on the bill in the House substitute that amends 100% of the language that was presented by our friends in the minority caucus. I believe it answers all the questions that came out during committee, and ask your favorable consideration. Happy to answer any questions.
You do have one question, Senator. Recognize the senator from the 6th.
Thank you, Mr. President. Senator, do you yield?
For the rules chairman, always.
I just want to make sure I heard you correctly. Did you say they amended 100% of the language?
No, we adopted 100% of the amended language that they wanted to add.
Thank you for the clarification.
You have no further questions, Senator.
Thank you, Mr. President. I yield the well.
Any other senator wish to speak for or against it? All right, the senator from the 48th has moved that the Senate agree to the House substitute to SB 212. All those in favor vote yea. All those opposed, nay. Secretary, unlock the machine. On the motion to agree, the yeas are 53 and the nays are 0, and this motion prevails. Recognize the senator from 38th.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 93.
Secretary, read the caption.
Senate Bill 93 by Senator Kemp of the 38th and others, the bill to be entitled an act to amend Code Section 20-2-153.1 of the official code of Georgia annotated the Georgia Early Literacy Act so as to prohibit the three-queuing system from inclusion in high-quality instructional materials or structured literacy, to prohibit public schools from employing the three-queuing system or visual memory as a basis for teaching word reading, to provide for criteria for core curricula and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 93. Bills will be entitled an act to amend Code Section 20-2-153.1 of the official code of Georgia annotated the Georgia Early Literacy Act so as to provide for criteria for core curricula for state-approved educator preparation programs aligned to the science of reading, to guide curricula and instruction, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Recognize the senator from 38th.
Thank you, Mr. President. Colleagues, I rise in asking for your favorable consideration in approving House Senate Bill 93. This bill, as you all know from me coming up before, addresses our literacy initiatives in the state to ensure all of our students are reading on grade level. We have found through science and research that a method called three-queuing was not being effective in teaching our children how to read, and that ban was accomplished in House Bill 307, which we've passed, that was sponsored by Representative Bethany Ballard. And so the House amended Senate Bill 93 to take that language out so that we do not send duplicative language to the governor. And so this bill now just makes sure that we're preparing teachers for how we expect students to learn how to read in our classrooms. So I worked with the Professional Standards Commission to come up with this language, and I think it will make a huge impact in addressing the fact that 70% of our children are not reading on grade level. And I am very excited to see the impacts that this has in the future to make sure that students are taught properly how to read. And with that, Mr. President, I will yield for any questions if there are some.
Senator from 42nd.
Thank you, Mr. President. Senator, you yield for a series of questions.
Yes, sir.
Senator, isn't it true that this is your very first bill, correct?
Mr. Attorney General, I'm sorry.
No further
Senator
questions.
From the 42nd, this is my first bill.
That was good. Now you throw me off. Isn't it true that if we pass this bill, this is final passage?
This will be final passage of this bill, that's correct.
So that means, I think I'm correct, that you will be the first freshman in this class of either party to take a bill all the way to the governor's desk this year. Is that true?
I actually do not think that is correct. The senator with the fly J's on today has a bill that is going over to the governor.
The guy who gets handed bills from the governor, right?
Yeah.
Right. Other than the guy who gets handed bills from the governor, you're the first freshman to take a bill all the way through both chambers to the governor's desk if we pass this bill. Is that true?
I absolutely worked very hard to get this bill to the point that we're at, so you're correct.
So my question is, does that mean you consider yourself, other than the freshman floor leader over there, to be the most effective freshman senator in this body?
I believe that I am amongst some very effective freshmen, and so I consider myself to be in great company.
One last thing. I did some quick research about the other Senator Kemp, who used to be here years ago, and I found that it took him 2 years to pass his first bill through both chambers and get to the governor's desk at the time. Isn't that true?
That may be true, but I'm excited to be behind him when he signs this bill.
Well, considering that, do you consider yourself to be the most effective Senator Kemp to ever serve in this body?
Oh. I just hope that he's not the only Senator Kemp that became Governor Kemp. Let's leave it at that.
Man, I tell you what.
Yeah.
You get thrown a softball and you swing and miss like no other. Get out of here. We're done
All
with
right.
you. Go
Thank you,
on.
Mr. President. I yield the well.
Good job, Senator. Good job, Senator. All right. So the senator from the 38th has moved that the Senate agree to House Substitute Senate Bill 93. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the agrees, the yeas are 55 and the nays are 0, and this motion has prevailed. Good job, Senator. Recognize Senator from the 24th.
Mr. President, I ask that House Bill 308 be elevated from the table.
House Bill 308 by Representative Clifton on 131st and others, a bill to entitle an act to amend Title 40 of the OCGA related to motor vehicles and traffic so as to provide for the operation of miniature on-road vehicles on certain highways, to provide for standards for registration of such vehicles, to provide for issuance of license plates for miniature on-road vehicles, to provide for annual licensing fee for such vehicles, to provide for issuance of certificates of title by the Department of Revenue for such vehicles, and for other purposes. That completes the order, Mr. President.
Is there objection? Bringing it on the table? Hearing none, Secretary, finish the caption.
House Bill 38 by Representative Clifton on 131st and others, bills to entitle an act to amend Title 40 of the OCGA related to motor vehicles and traffic so as to provide for the operation of miniature on-road vehicles on certain highways and for other purposes. Mr. President, the Senate Committee on Public Safety recommends that this bill to pass with respect with 2 minutes. Senator Albers, Chairman. That completes the order.
Recognize Senator from the 24th. Oh, Senator, stand right there. We got to read the amendment. Stand right there, Senator. Just stand right there. We got to read the amendments. Got a couple of amendments.
Mr. President, Senator Kirkpatrick of the 32nd and others offer the following amendment. Number 1, to amend House Bill 38 by replacing line 8 with the following: to provide a sentencing court with authority to order the installation of a device which limits the speed of a motor vehicle as a part of the punishment and for other purposes. Mr. President, Senator Brass of the 6th and others offered the following amendment. Number 1A, to amend Amendment 1 to House Bill 308 by replacing line 8 with the following: tinting or unlawful installation of such, to revise and provide for definition, to provide for the issuance or a refusal to assign citation, provide for penalty, to amend Code Section 48-5-473 of the official code, and for other purposes. Mr. President, Senator Brass of the 6th and others offered the following amendment. Number 2, to amend House Bill 308 by replacing line 8 with the following: to revise and provide for a definition, to provide for the issuance or of a refusal to sign a citation, and for other purposes. Mr. President, that completes the order.
Thank you, Mr. President. I bring you House Bill 308. This is a small bill for the where we have miniature trucks. We need to have this bill passed because this helps you to be able to, it's found its place in the workplace and also on the farm. And all it simply does is make it to where miniature trucks will be able to be registered and we can collect the revenue also from them. We have two friendly amendments, and I'm going to let both senators present their amendments. I ask you to vote green.
You have no questions, Senator. Recognize Senator from the 32nd.
Thank you, Mr. President. Amendment 1 has two parts. The first part will look very familiar to y'all. We've already passed it out of this chamber before, and it has to do with reckless stunt driving and placing a speed limiting device on the vehicle after the second conviction. The second part in Section 11 updates our law to classify window tint violations as an equipment violation, just like a missing headlight or smashed window, rather than a fingerprintable offense. And with that, I'd be happy to take questions.
You do have a couple questions, Senator. I recognize Senator from the 50th.
Thank you, Mr. President. Does the senator yield?
Sure.
Earlier, the senator came up and spoke about miniature trucks. I'm assuming they're for smaller people. My question is this a bill for our current ag commissioner?
Actually, sir, it is not. He did not have anything to do with this part of the bill. He may have spoken to the senator from the 24th about it, but my amendment is unrelated to the Commissioner of Agriculture. Thank you.
Recognize Senator from the 53rd.
Thank you, Mr. President. Point of order. I don't have the amendment on my desk, one. And I'm not aware of any other senator who has your amendment on their desk.
It should be in his book, right?
Amendments 1 and 2 are in the back of the book, and Amendments 1A is circulating right now.
You have it.
In the back of the book. And then the other 1A is supposed to be passed around. Senator from the 53rd, we'll come back to you. I'm just going to address a couple other people who have questions, but we'll come back to you if you still have questions. Recognize Senator from the 29th. Recognize Senator from the 41st.
Thank you, Mr. President. Madam Chairwoman, do you yield?
Absolutely.
Would you be so kind as to speak to your amendment once more now that we're able to see it?
Sure.
Thank you.
The first part of the amendment it adds back the language about reckless stunt driving that we passed out of this chamber before. And the second part of the amendment has to do with updating the requirement that fingerprints have to be obtained with a window tint violation. So it makes that an equipment violation rather than a moving violation.
All right, Senator from the 53rd, you still have a question? All right, Senator, you can yield well.
Thank you.
Does any other senator wish to speak? Oh, Senator from the 6th. Yeah, you have an amendment we need you to speak for. Senator from the 6th. Your amendment.
Mr. President, this amendment was actually HB 483, if y'all would like to reference that. You know me, I like to keep a tight calendar. I didn't want to put too many bills on the floor, and so we're bringing this amendment to put on here. And simply, quiet down. Simply what it does, under current law, if you don't sign your traffic citation, you go to jail and have to post bond. This just simply says if you don't sign your traffic ticket, all you have to do is show up to court. You will be mandated to show up to court. This is just to help prevent keep our officers a little safer. That I'll yield for questions.
Recognize Senator from the 29th.
Senator Yield?
I certainly will, for the king of public safety.
Senator, reading the amendment on, if you look at line 16 where it starts at the officer, it says the officer may bring the person before a judicial officer or traffic violations bureau to post a bond as is otherwise provided by law. Does this amendment prohibit an officer from making that discretionary decision? And so this does not prevent an officer, if someone refuses to sign the citation, if they need to or feel necessary, they can still take the person in and have them post bond. Is that correct?
That's my understanding.
Thank you.
Recognize Senator from the 19th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Thank you. I have a legitimate question here. If you don't sign the ticket, how does the prosecutor prove that the offender or the alleged offender had notice in a court proceeding?
Well, there's cameras. You got body cameras. You got car cameras. We got other cameras, but we'll talk about those later.
All right. I just didn't know if that was something I was missing. Thank you.
Recognize Senator from the 46th.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
So most times when a person gets a ticket, they have a choice. They can go online and just pay that ticket, or they can go to court and contest it. In this situation, does the person have the opportunity to just pay their fine online, or does this make them have to go to court just because they failed to sign the ticket?
If they refuse to sign it, they would have to go to trial. If they're just going to pay it, there'd be no reason not to sign it.
But even if they wanted to pay it without going to court, they're no longer able to if they didn't sign the ticket?
The way this amendment is written, that is correct.
Okay, thank you, Senator.
Recognize the senator from the 38th.
Thank you, Mr. President. Is gentleman yield?
I yield for the freshman.
Mr. Chairman, is it not true that passing an amendment like this will help prevent deaths that occur as a result? For example, Johnny Holloman was killed as a result of not signing a ticket, and many folks don't understand that you do not have to sign the ticket, but this will help prevent those situations from occurring.
It could,
again.
that's certainly true, but it could also prevent our officers less time standing in harm's way.
That's right.
So
Thank you, sir.
when you've got officers standing near traffic, the less time they got to be there, the better it is for everyone involved.
Is Jim for the yield?
Absolutely.
So this amendment would be helpful to officers and the general public, helping keep both of them safe. Is that
That is
correct?
my belief.
Thank you, sir.
Recognize senator from the 26th.
Thank you, Mr. President. Senator, you yield.
For my good friend from Macon, of course I do.
Isn't it true that if you do not sign the citation, the officer can take you in and you make bail there rather than signing the citation and saying that you will appear in court?
I believe that to be true. I think I understood the question. What?
I recognize the senator from the 53rd.
Thank you, Mr. President. With the senator yield?
Yes.
Following the sentiments from the senator from the 19th, what if a rogue officer issues a citation, there's no receipt of that to the perceived perpetrator? What keeps a rogue officer from just essentially putting citizens in jail because they didn't even know they had gotten a ticket?
Well, under this amendment, they'd have to have a right, or they'd have to have a reason to put them in jail, and not signing the ticket is not a reason to put them in jail under this amendment.
That they wouldn't know to show up in court. They'd be in contempt of court, wouldn't they not?
Sure. Okay. I yield the well.
Yeah, that's probably a good idea. You still strong as oak, though. You're my rules chair and strong as oak. Recognize the senator from the 22nd.
Thank you, Mr. President. I'll be brief. Just to address a couple of things. The purpose of this amendment, is a good amendment, is one to actually try to reduce some of the friction that may take place between officer and also citizen encounters. And that's one of the things that you want to do. As far as having your road, quote unquote, road deputy, remember, the person is still going to be receiving the ticket with the court date on there, with all of his or her information still on that particular ticket. They're going to receive that. So it's not like they're not going to have any notification at all. And also, depending on the charge, it also depends on the jurisdiction, they may also receive something in the mail. And it's really just going to depend on the jurisdiction and the charge. But they're going to receive that notification that they have that. And of course, that will be on record with the prosecutor's office, meaning they're going to have Harold Jones' name, his address, his or her phone number, his or her driver's license number, and so is Harold Jones going to have it. It's just going to say that I refuse to sign the ticket. It's not going to necessarily change the notification process at all. And quite frankly, even though you could actually potentially arrest somebody for doing this, in Augusta, Richmond County jurisdiction, when I was prosecuting way back in the 90s, deputies would go ahead and avoid that confrontation, and they would just refuse to sign the ticket, and the person would come to court and they would explain why they refused to sign the ticket. But I do want to make note that we're not dealing with rogue deputies. Being a former prosecutor, I think that's a bad terminology really to use, to have that. This is something that's actually going to reduce citizen and police encounters that can escalate, and it's something I think will actually protect deputies and will actually protect the citizens too. With that, we'll yield for any questions.
The senator from the 2nd.
Thank you, Mr. President. Senator, do you yield?
Yes.
Senator, is it not true that you are a solicitor?
Yes.
And Senator, is it not further true that you would handle these type of traffic citations? Is that not also true?
That's correct.
And Senator, is it not further true that sometimes folks in the general public get confused that if they don't agree with something, that they just don't want to sign it when the law currently says they have to sign it? So this would just take that out of the situation altogether and just make sure our law enforcement folks make it back home. Is that not true?
That's exactly right. Many times you've seen on television where a person say, I don't want to sign it, and sometimes those things can escalate. This will actually eliminate a possibility.
Yeah, one more question, Senator.
Thank you.
Recognize the senator from the 42nd.
The senator yield.
Yes.
I also think this is a great amendment. I appreciate what you've added to the discussion. Isn't it true when we were asked earlier about someone that just wants to pay a ticket, that this bill does not prevent somebody still from just paying a ticket they want to pay, but the current law is if you don't sign your ticket, you go to jail. You have to post a bond. And this law says if you don't sign your ticket, you'll just have to appear in court instead. Isn't it true?
That's correct, because current law, you'd actually be possibly taken to jail.
Right.
Absolutely.
Thank
Thank
you.
you, Mr. President. Yield the well.
Thank you, Senator. Any other senator wish to speak for or against the measure? All right. Got 3 amendments here. We'll start with Amendment 1A, authored by the senator from the 6th. Wait a minute. Who carried this bill? Did they want to close? I don't even remember who carried this bill now. Do you want to close, Senator? You good? Okay. All right. Amendment 1A, authored by the senator from the 6th. Is there objection to 1A? There's objection to 1A. All those in favor of Amendment 1A will vote yea. All opposed, nay. Secretary will lock the machine. On the adoption of Amendment 1A, the yeas are 49, the nays are 6, and Amendment 1A is adopted. Now the question is on Amendment 1 as amended, authored by the senator from the 32nd. Is there objection to Amendment 1? There is objection. All those in favor of Amendment 1 as amended will vote yea. All opposed, vote no. Secretary, unlock the machine. On the adoption of Amendment 1, the yeas are 50 and the nays are 5. Amendment 1 is adopted. Now on to Amendment 2. Senator, authored by the senator from 6. You got to state it on the mic there, Senator.
Mr. President, you just like hear me talk, don't you?
Yeah.
Mr. President, I ask unanimous consent to remove Amendment 2.
All right. I'm sure there's no objection, right? All right, hearing no objection, Amendment 2 is withdrawn. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none, the report of the committee is agreed to. Is there objections to the main question being ordered? Chair hears none, the main question is ordered. Question is on the passage of the bill as amended. All those in favor vote yea, all those opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 47, the nays are 6. This bill, having received the requisite constitutional majority, is therefore passed as amended. Recognize the senator from the 42nd.
Mr. President, I move that House Bill 339 be lifted from the table.
Secretary, read the caption.
House Bill 339 by Representative Lovett, 123rd, and others, bill to be entitled Act to amend Article 3, Chapter 1 of Title 40 of the Official Code of Georgia annotated related to motor carriers so as to exempt rideshare drivers or rideshare network services from the definition of motor carrier, to provide for definitions, to derive legislative findings, to exempt rideshare network services from liability for actions of rideshare drivers in certain instances and for other purposes. Mr. President, that completes the order.
Recognize the very busy senator from the 42nd. I mean, you were in the newspapers today and everything.
It's been a big day, Mr. President. All right, I bring to you House Bill 339. This bill deals with liability, civil liability for our rideshare network services. These are the folks like Uber and Lyft that provide rideshare services in our state. It's a bill that was negotiated with all the interested parties involved that confirms that these companies would not be liable for any type of damages, including vicarious liability or prox liability, unless they directly are negligent. They do some sort of criminal conduct. They don't follow our existing laws they're required to follow for this industry. And if they don't conduct background checks every 2 years as required by law. It also confirms that these services are not a product. We're not getting into product liabilities. This is a good reform bill when you look at our civil justice side of things and how to deal with these type of companies. It frankly is what the law ought to be anyway, and I think it confirms that, and it'll help also make sure we don't get out of control litigation in our state when looking at these services that could drive up costs for all citizens. Happy to take any questions.
You do have a question. Senator from the 22nd.
The gentleman yield?
Yes, sir.
The requirement of negligence still is there as far as the rideshare companies are concerned. Is that correct?
That's correct. This is not an immunity bill. So the service itself, the company would have to commit negligence in order to be liable for that type of case.
All right, thank you.
You have no further questions, Senator.
Thank you.
Oh, I'm sorry, Senator, you do have one. Probably be a friendly, since y'all both trial lawyers.
I don't know.
Bill.
He doesn't like my tort
Senator
reform.
from the 19th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, if your bill were to pass, what are the underlying minimum limits that a driver for a rideshare company would now have to have?
It doesn't change whatever existing law is.
Well, Senator for the Yield?
Yes.
Do you know what those are currently?
Yes, it is on lines 39 and 40 of the bill.
So then, Senator for the Yield?
Yes.
So now the driver will be responsible for having liability insurance in an amount of at least $100,000 per person and $300,000 per an accident?
That's the current law. We didn't change that.
Okay. Thank you.
And again, we sit next to each other. You could ask me these questions in advance, and it wouldn't have to be like this.
Will the Senator further yield?
Nothing. I need to yield the well. Thank you.
Senator is yielded. Does any other senator wish to speak for or against the measure? Hearing none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Question is on the passage of the bill. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 54th, you're on deck. On the passage of the bill, the yeas are 46 and the nays are 7. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 54th.
Yes, Mr. President, I ask to remove House Bill 253 from the table.
Secretary, read the caption.
House Bill 253 by Representative Clark of the 100th and others, a bill to entitle an act to amend Chapter 11, Title 15, and Article 1 of Chapter 9 and Title 19 of the official code of Georgia annotated related to juvenile code and general provisions, but also to child custody proceedings, so as to enact Ethan's Law, to promote limitations, and for other purposes. That completes the order, Mr. President.
Is there objection? Out of objection. Secretary, finish the caption.
House Bill 253 by Representative Clark, the 100th and others, a bill to amend Title and Act to amend Chapter 11, Title 15, and Article 1 of Chapter 9 and Title 19 of the OCGA related to juvenile code and general provisions relative to child custody and for other purposes. Mr. President, the Senate Committee on Children and Families recommends that this bill do pass by substitute. Respectfully submitted, Senator Kirkpatrick, Chairman. Mr. President, the Senate Committee on Children and Families offers the following substitute to House Bill 253, a bill to amend Title and Act to amend Article 1 of Chapter 9, Title 19 of the OCGA related to general provisions relative to child custody proceedings, so as to prohibit the court from ordering family reunification treatments or services in cases in which the custody of a child and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 54th.
Thank you, Mr. President. Friends, I'm honored to bring you House Bill 253, a measure designed to better protect children and parents subject to child custody orders issued by superior courts in our state. Under current state law, superior court judges have the authority to order children to attend reunification camps outside of our state. This not only removes the child from our jurisdiction, but it also infringes upon parental rights. Today, parents with sole custody are being forced under court order and the threat of contempt to send their children across state lines for reunification with a parent who is previously deemed unfit for custody. This is unacceptable, especially when Georgia has thousands of highly qualified counselors, therapists, and mental health professionals available to provide services right here in our state. House Bill 253 is about safeguarding children, upholding parental rights, and ensuring that our judicial system remains informed about the responsibilities. I encourage all of my colleagues to stand with me and let's support this and stop this practice in our state. Mr. President, there are questions. I will yield the will.
You have no questions, Senator. Is any other senator wish to speak for or against the bill? Chair hears none. Is there objection to a previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of HB 253, yeas are 55 and the nays are 0. And this bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize Senator from the 49th.
Mr. President, I ask for unanimous consent to remove House Bill 491 from the table.
Secretary, read the caption.
House Bill 491 by Representative Chastain of the 7th and others, a bill to amend Title and Act to amend Article 1 of Chapter 3 and Article 2 of Chapter 4 of Title 27 of the OCGA related to hunting and non-commercial fishing respectively, so as to remove an exception for the use of air guns to hunt wildlife, to revise provisions concerning the taking care of catfish by bow and arrow, to provide for related matters, to repeal milking laws, and for other purposes. Mr. President, that completes the order.
Is there objection for removing it from the table? Hearing none, Secretary can finish.
House Bill 491 by Representative Chastain to the 7th and others, bill to be entitled an act to amend Article 1 of Chapter 3 and Article 2, Chapter 4, Title 27, and for other purposes. Mr. President, the Senate Committee on Natural Resources and the Environment recommends that this bill do pass. Respectfully submitted, Senator Anderson, Chairman. Mr. President, Senator Summers of the 13th and others offered the following amendment number 1 to amend House Bill 491 by inserting before to provide for related matters on line 4 the following: to extend the firearms, archery, and primitive weapons hunting seasons for deer by inserting between lines 20 and 21 the following. Section 2 said article is further amended by adding a new code section to read as follows: 27-3-51 beginning on July 1st, 2025, firearms, archery, and primitive weapons hunting seasons for deer shall extend as follows, Mr. President, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 49th. Senator from the 19th, you have your light on. Do you have a question later?
Thank you, Mr. President. I bring to you HB 491, another heavy lift from the freshman senator from the 49th. This is a bill from the DNR, and it does two things, really. It simply extends the sunset on hunting with air guns from July 2025 to hunting season of 2030. These guns can be used during primitive weapons hunts, also primitive weapons seasons, and firearm seasons. The bill also allows catfishing anywhere in the state of Georgia with a proper bow, arrow, or tow rope. Thank you. I yield for any questions.
Question, Senator.
I figured.
I recognize the senator from the 19th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, I've been busy doing the budget today. I'm just now getting to read some of these bills. Does this bill say you can hunt catfish with a bow and arrow?
The gentleman knows of what he speaks.
Can you explain that for me, please?
I've never participated in this, but I understand that it's a growing sport in the state of Georgia, and we're expanding it all across the great state of Georgia.
Well, Senator, further yield.
Yes, sir.
Well, it's like the old language said you couldn't do it in the Savannah River, and now it allows you to do it anywhere, and it gives you some limitations. However, those limitations are waived if on lines 40 and 41 you're hunting at night with a light. Is that correct?
That's correct.
Senator, can you explain to me the logical reason for waiving all the other requirements if you are hunting with a bow and arrow at night with a light?
Senator, like I said, I've never done it. I've seen a few videos, but I understand those fish are a little less active at night and a little bit more still and easier to shoot with a bow. Kill them while they're sleeping, sir.
I'm speechless. I appreciate it.
All right. Recognize senator from the 42nd.
That's Senator Yield.
Of course.
Senator, when you're hunting these catfish at night with your bow and arrow, do you actually have to get in the water to do that, or you do it from the shore?
I think you can do it from the shore. You can do it from a John boat, or you could be waiting. I would assume that the country lawyer from the 42nd would understand these country tactics.
Do you further yield?
Yes, sir.
Is the reason you wore those shoes today, you wanted to show us the type of shoes you'd wear when you're hunting catfish with a bow and arrow in a pond at night?
Sir, you were in the AJC earlier today, and I would suggest you come to my haberdasher.
Senator from the 6th.
Thank you, Mr. President. Does my good friend who dressed up like the AJC today, do you yield?
Yes, sir, Mr. Chairman.
Senator, the senator from the 42nd over there sure does like to ask you a lot of questions, and he references you. And when other people are on the well, do you have an opinion on why that might be?
I think he likes my clothes. That's all. There's a lot I could say. There's a lot I could say about his obsession, but I'll just leave it at that. I yield the will, Mr. President.
All right. Senator from the 13th. I see you have an amendment.
Thank you, Mr. President. Colleagues, this is a simple amendment that we're adding to the bill. The author of the bill is okay with this. Basically, what we're doing is we're extending deer season out and we're allowing the Department of Natural Resources to decide the days, but we're giving 14 additional firearm days. Archery gets 7 days, and primitive weapon gets 9 days. In South Georgia, we're inundated with deer, and the season is too short, and we're just not keeping up with the population. It's wrecks every time you turn around. And I appreciate the senator let me put the amendment on the bill, and I hope that you all vote in favor of the amendment and allow the department to decide what days it goes. Mr. President.
Hold on, Senator. You got some questions here. Recognize Senator from the 53rd.
Thank you, Mr. President. Point of order. I think what the senator is offering his amendment sounds like a great amendment. I just don't have it on my desk.
It's in the back of your book, on the very, very back.
Of the book. All right.
Recognize Senator from the 19th.
Thank you, Mr. President. Senator, do you yield?
Absolutely.
To a series of questions? Thank you. Got some question about your deer hunting. Can you hunt them in the night?
Absolutely not.
Can you hunt them with a light?
Only if you get a permit. Yes, you can.
Can you hunt them from the air?
You can spot them from a drone.
Can you hunt them anywhere?
Well, maybe so. Thank you, sir.
That's Dr. Zeus there.
Any more questions, Mr. President?
I mean, we've gone to catfish hunting, to reading the story time, but yield well, Senator.
Yield.
We went from a bad bill to a bad amendment to, good Lord. Senator from the 6th. I don't know. Senator from the 26th, they about to mess up our rabbit hunting now. He done gone to meddling now.
Mr. President, that is why I'm here, the little man fighting for the little man. We got a lot of deer hunters here in this state. We've got very few rabbit hunters, and I feel like they need a voice. The longer you push the deer season, the further you push rabbit season into spring, warmer weather. Snakes can get the dogs. Vote this amendment down. This is for America.
The real reason, since there's only 2 rabbit hunters in here, it's myself and the senator from the 26th, and the reason why we don't want it to go in deer season to go into rabbit season is because we're more worried about the hunters than we are the snakes. And now we're gonna have guys out there with bows hunting catfish. That's gonna make it even more. Senator from the 26th.
Parliamentary inquiry on a serious note. Mr. President, isn't it true that now we have more claims, insurance claims with deers and cars, and in neighborhoods now, because they've been built up, the deers are coming out in the neighborhoods, and people are hitting the deers in the neighborhood and doing the damage to the cars, and now we have the large insurance claim against car owners who hit a deer.
Senator, you are exactly right. There's more people hitting deer right now. All right, Senator from the 25th, you have a parliamentary inquiry, what?
Yes, sir. Parliamentary inquiry.
State your inquiry.
When I came along, Mr. President, we hunted deer in the daytime and rabbits at night. That way the seasons didn't coincide with each other.
That was a long time ago, Senator. Recognize Senator from the 19th.
Thank you, Mr. President. Point of order.
Yes, sir.
Did deer and catfish we just link?
I'm sorry, say it again.
Just say yes, if you don't mind, Mr. President, if you would say yes. Did deer and catfish we just link?
Cut his mic off.
Should we clean them in a sink? Must we hunt them wearing pink?
All right, here we go. Oh, my goodness. State your inquiry, Senator from the 13th.
Thank you, Mr. President. Parliamentary inquiry. Isn't it true that when you run into a rabbit, you don't total your car?
Just depends on the rabbit, Senator. Could be a daddy rabbit, right? All right, here we go. Let's move on. We can talk to us catfish and everything else. So we have an amendment here. Amendment number 1, sponsored by the 13th. Is there objection to amendment number 1? There is objection. All those in favor of amendment number 1 will vote yea. All opposed, nay. Secretary, unlock the machine. On the adoption of Amendment 1, the yeas are 53 and the nays are 2. And this amendment has been adopted. Is there objection to agreeing to the reporting committee which is favorable to the bill? Passage of the bill, chair hears none. The reporting committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. Recognize the senator from the 49th. What purpose you rise?
Parliamentary inquiry, sir.
State your inquiry.
Isn't it true that hard-working Georgians can fish at night with the passage of this bill?
I don't know when it's been illegal to fish at night, Senator. On the passage of the bills, the yeas are 52 and the nays are 3. And this bill has reached the requisite constitutional majority and therefore is passed as amended. Recognize the senator from the 42nd.
Mr. President, I ask unanimous consent that House Bill 176 be lifted from the table.
Secretary, read the caption.
House Bill 176 by Representative Smith of the 18th and others, a bill to be entitled Act to amend Title V of the OCGA related to appeal and error so as to change provisions related to judgments deemed directly appealable, to change provisions related to cases requiring application of appeal, to provide for definition, to provide for out-of-time remedy for certain types of post-judgment relief in criminal cases, to provide for procedure of time frames, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
House Bill 176 by Representative Smith of the 18th and others, bills to be entitled Act to amend Title V of the OCGA related to appeal and error, such as to change a provision related to judgments deemed directly appealable, to change provisions relating to cases of requiring application of appeal, to provide for definition, to provide for out-of-time remedy for certain types of post-judgment relief in criminal cases, to provide for procedure and time frames, change provisions related to amendments on motions for a new trial, to amend Code Section 17-7-93 of the OCGA related to a reading, indictment, or accusation answer of accused to charge, recordation of guilty plea, and the pronouncement of judgment, withdrawn guilty pleas and pleas by immigrants, so as to provide for a time frame regarding the withdrawal of a guilty plea, provide for related matters, provide for effective dates, repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, Chairman. That completes the order, Mr. President.
Recognize Senator from the 42nd. Very busy senator today.
Thank you, Miss. Did you cut me off? Not yet. Thank you, Mr. President. House bill, on a serious note, even though I'm wearing my rabbits on my tie today, I didn't realize that until a minute ago. House Bill 176 is a really serious bill that deals with criminal law post-judgment appeals. Doesn't sound very exciting to a lot of y'all, but this bill is in response to a couple Supreme Court decisions that has created some doubt and some confusion as to how some of these post-judgment matters will be decided. And so we're addressing the process for filing out-of-time notices of appeal. We're addressing the process for how you file appeals when some of the charges are dead docketed, if something happens in a lot of cases. We're also cleaning up the process to how you challenge a plea that's taken. So a lot of this stuff is in the weeds, but it's a bill that's been, I think, at least 3 or 4 years in the works. I know last year we tried to get this done. That may not be very exciting to you, but it's very important for those that deal with criminal law and are facing charges in our state to make sure the process works for everybody. Happy to answer any questions.
You have no questions, Senator.
I ask for your support of House Bill 176.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 52nd.
Thank you, Mr. President. I ask unanimous consent to remove House Bill 370 from the table.
Secretary, read the caption.
House Bill 370 by Representative Gaines on the 120th and others, rules between town and acts amend code section 48-5-34 of the official code of Georgia annotated related to ad valorem property bill form so as to require the property tax bill for any school district that opts out of the statewide base year homestead exemption to state the total amount for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, finish the caption.
House Bill 370 by Representative Gaines on the 120th and others, bills being titled an act to amend code section 48-5-34 of the OCGA related to ad valorem property tax bill form so as to require the property tax bill for any school district that opts out of the statewide base year homestead exemption to state the total amount of the school district's reserve funds to require the statement of the property tax bill regarding certain political subdivisions and for other purposes. Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Hufstetler, Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to House Bill 370. A bill to be titled an act to amend Article 2, Chapter 7, Title 48 of the OCGA related to imposition rate computation exemptions and credits for income taxes so as to create a tax credit for certain employers that offer individual coverage health reimbursement arrangements to employees, to provide for terms, conditions, and limitations, to provide for pre-approval, to provide for aggregate annual limits, to provide for rules and regulations, to provide for definitions, to provide for a sunset, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 52nd.
Thank you, Mr. President. This bill is a department bill from the Department of Insurance. The commissioners want to use what are called ICRAs. They were created in 2019. These are individual coverage health reimbursement accounts. This would be only for employers that have 50 or less employers, because if you have above 50, then it's a requirement that you offer some sort of coverage. And it would allow a credit against them contributing to an employee's account to let them purchase insurance on their own. They have to contribute at least $2,400 to that account, and they would be eligible for a credit of 25%. The original bill had a 5-year sunset. We actually cut it down to a 3-year sunset because it is a pilot program capped at $5 million, and we wanted to look at it and see if this is going to be effective. He feels like this is a good plan to reach a niche of people who don't have health coverage. If there's no questions, I'll yield the well.
You do have one question, Senator. Senator from the 20th.
Will the senator yield?
I'll yield.
So on line 19, I know this has kind of been debated a lot over in the House, and the number changed, but it's now 50 or fewer employees, and it has given the employer a tax credit, not a tax deduction, for the contributions to I guess incentivize the employees to go and get an ACA plan through the what we now call Georgia Access. And I just don't understand why an employer as big as 50 employees would not offer group coverage. And this seems like to me it's incentivizing them to not offer group coverage to avail themselves of this tax credit. And if they were doing group coverage, they would get a deduction for what they're paying for the group health insurance. It'd be a normal business deduction, but now we're going to give them a credit. So why would an employer want to offer group coverage anymore?
Well, if they already offered a plan, they can't have any other plan to be eligible for this. And originally, the bill had a 50% credit. We cut it down to 25%. We cut it down to 3 years. Our insurance commissioner feels like there's a group of people that this would be helpful to, and so it's a trial program.
Would you further yield?
I'll
Mr.
yield.
Chairman? So I have great respect for the insurance commissioner. I don't understand why we want to incentivize a business not to do group coverage when we're basically incentivizing people to go on a government subsidized plan through Georgia Access. We're subsidizing that through this massive amount of reinsurance money we're putting in behind it to backstop it and keep the rates low. And now we're going to give a credit to even encourage that further. I'm just confused.
Well, I
Can
think
you help me?
They also can be used for the employees can use them for health reimbursement as well. But those are, I believe, 100% federal funded plans, and we're trying to encourage people to get on a health care plan.
Thank you.
No more questions, Senator.
Thank you, Mr. President.
Senator from the 35th.
Colleagues, I'm going to be very quick, and I'm going to vote in support of this program because I appreciate the intent of the program and trying to get our small business owners to help our citizens enroll into Georgia Access, providing subsidies. But I want to provide you an example of how we took what could have been a pretty good pilot program and likely made it unusable for the average small business owner, which is what I think the insurance commissioner intended. Let me give you an example. If you were a small business owner and you have 20 employees, the original bill would have required you to spend $24,000 over the course of the year in subsidizing health care, and you would have received $12,000 back. So you would have spent $12,000. Now, as a small business owner myself, that's something that is appealing if I had not provided that benefit before. With the change that we made, the small business owner would have to, with the same number of employees, spend $48,000 and only receive $12,000 back, which means they would ultimately spend $36,000. So a pilot program that could have meant a small employer being able to help their employees, incentivize them to get health care for $12,000, now turns into a program where to get the same kinds of incentives, you would need to spend $36,000. And for the average small business owner, that's a lot of money to be trying to add an additional benefit. So just wanted to point that out, that we took what could have been a perfectly good pilot program and turned it into something that will likely be unusable for the average small business owner. Mr. President, I yield the well.
Recognize the senator from the 20th.
Thank you, Mr. President. I really hate to have to come down here and speak against this bill because I got tremendous respect for the senator from the 52nd and obviously the insurance commissioner. I know the intent is to try to have fewer uninsured citizens in Georgia. I just think this is the wrong way to go about it. I'm not clear if the $200 a month that they're going to give to the employee is going to be subject to income tax. I guess it would not be, but to me, if this was for a small business of say 5 employees or maybe 10 employees, I wouldn't have the heartburn. But to me, a business is 50. They ought to be offering group benefits. We're in a workforce shortage in Georgia. We're having to compete for talent and compete for employees, and providing benefits to your employees is one way to attract and retain employees. I just think this is the wrong way to try to push more people. We're basically going to push more people into a government-subsidized health insurance program. The health coverage is not nearly as good as what you could get through a group plan, a traditional type plan. And we're funding this already. We're subsidizing those rates already through the state budget, and it's millions and millions of dollars we put in to subsidize these rates, and now we're going to give credits to try to put more people on this plan. I don't understand it really, but anyway, I ask you to vote no, please. Thank you.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? I'm sorry, Senator. Would you like to close the debate? You did such a masterful job. I didn't think it was needed.
Thank you, Mr. President. Again, if you're already on another plan, you're not eligible for this. These are people that aren't on a plan, and these plans, the exchange that people can get these plans on are 100% funded by the federal government. We're not pushing people onto something that's going to cost the state money. I'm not that familiar with these. They started in 2019. But they seem to have worked in other states. Our insurance commissioner wanted to try it. We said he could try it. We did cut him down from 5 years to 3 years to give him, a little bit less time to make sure we're comfortable with it, and I would urge your support of this bill.
Thank you, Senator. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 43 and the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 25th.
Thank you, Mr. President. I request that House Bill 78 be lifted from the table.
Secretary, read the caption.
House Bill 78 by Representative Franklin, the 160th, and others. A bill to amend title and act to amend Article 7 of Chapter 20, Title 47 of the OCGA, the Public Retirement Systems Investment Authority Law, so as to raise the limit for the total percentage of funds that the Employees Retirement System of Georgia may invest in alternative investments, provide for related matters, for repeal looking laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Objection. Finish the caption.
House Bill 78 by Representative Franklin on the 160th and others. A bill to amend title and act to amend Article 7 of Chapter 20, Title 47 of the OCGA, the Public Retirement Systems Investment Authority Law, and for other purposes. Mr. President, the Senate Committee on Retirement recommends that this bill do pass. Respectfully submitted, Senator Williams, Chairman. Mr. President, that completes the order.
Recognize the senator from the 25th.
Thank you, Mr. President. This is a bill that we heard in retirement, and we vetted this completely. This allows ERS to make alternative investments. Right now, ERS is able to do this in 5%. This is going to allow them to do 10%. TRS is at 5%, but they don't want to go up at this time. The Georgia Firefighters Pension Fund and the Peace Office Annuity and Benefit Fund are at 15%, but this bill increases firefighters at their request up to 20%. Over the past 11 years, ERS has had an average return of 4 to 4.5% over public equities, and we ask for your favorable consideration. I yield the well.
Senator's yielded. Senator, do you want Senator to wish to speak in the well? I recognize Senator from the 46th.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I don't speak against many bills. I got very strong concerns about this. We're dealing with people's retirement funds, and what an alternative investment is an extremely risky, illiquid investment that is hard to sell. Many of them are extraordinarily high risk, like a stock option, that you really don't even own the equity. You're simply placing a bet that it's going to go up or down. Many of these are from venture capital funds that are captive funds that you can't sell them on the market. You're locked in for a period of years, and you're trapped whether they succeed or not. These are just very high-risk investments. That's why they may generate high yields. I don't think you gamble with retirement funds. Those of you with retirement accounts, if you talk to your investment advisors, it is very unlikely they're going to counsel you to take these high-risk investments when you need that money to retire on. And what I've noticed in our budgeting process for many years is we keep having to backfill these retirement funds to get them up to 80%. They are not generating enough money to be fully vested and funded themselves, so they're reaching out for Lifeline for a long shot, hoping they can hit it big on some of these investments, and this is not sound government, and I think these plans ought to be self-sufficient. They ought to be investing in secure investments, steady returns, instead of making these high-risk, illiquid investments, and for that reason, I'll be voting no. I'm happy to yield the well or take any questions.
You have
Mr.
no
President.
questions, Senator.
Thank you. I yield.
Recognize Senator from the 56.
Thank you, Mr. President. We've actually passed a Senate version of this bill out before. I always appreciate the great advice and wisdom from my friend and chairman from the 46th. However, you're right that we do have a problem with some of the retirement funds. We have to put more money in. This actually helps us to bridge that gap because the return on investment, the IRR on these funds, is significantly higher than a traditional investment. Just like each one of you have in your portfolios, you have a balanced portfolio. Some of yours happen to be in your small business. Some happens to be in real estate, whether it be your home or commercial, and some happens to be in different type of investments outside of the traditional stock market. This is a good practice that people have personally and in their businesses and our pension funds. And the data has shown year over year, now over a decade plus, that these returns are doing what we want to do. So I appreciate the concern, and we should all be good fiduciaries. This is an excellent bill, and I hope you all vote for it. Thank you. I'll yield the well.
Senator's yielding. Does any other senator wish to speak for or against the measure? Chair hears none. You want to close, Senator? You good? You waving it? All right. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 35, the nays are 18. This bill having received the requisite constitutional majority is therefore passed. The chair recognizes the senator from the 42nd. Again.
Mr. President, you can always stop recognizing me. I'll agree to quit. I move that we remove House Bill 131 from the table.
Secretary, read the caption.
House Bill 131 by Representative Reeves of the 99th and others, bill to be entitled an act to amend Article 5 of Chapter 4 of Title 10 of the official code of Georgia annotated related to self-service storage facilities so as to revise the advertisement requirements before the owner of a self-storage facility can force an owner's lien to provide for related matters, provide for effective date and applicability to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Objection. Secretary, finish the caption.
House Bill 131 by Representative Reeves of the 99th and others, bill to be titled an act to amend Article 5 of Chapter 4, Title 10 of the OCGA related to self-service storage facilities so as to revise the advertising requirements before an owner of a self-storage facility can enforce an owner's lien to provide for lien matters, provide for collective date, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, the Senate Committee on Judiciary offers the following substitute to House Bill 131, a bill to be titled an act to amend Article 5, Chapter 4, Title 10 of the OCGA related to self-storage storage facilities so as to revise the advertising requirements before an owner of a self-storage storage facility can enforce an owner's lien to provide for related matters, provide for an effective date and applicability, and for other purposes. Mr. President, that completes the order.
Recognize the Chairman of Judiciary, Senator from the 42nd.
Thank you, Mr. President. Members of the Senate, House Bill 131 deals with the advertising process for our storage facilities when there's going to be a sale. This is where someone's in default. The law, as it stays the same with this bill, there's certain things the contract has to say, and there's certain protections built in with due process for someone who doesn't pay for a storage facility unit. We don't change any of that, but it gets down to the sale itself. The current law has an outdated process where the owner has to advertise twice in the legal organ to conduct a sale. And this is something that the industry has come and said it's costing us a lot more money. We're having to pass along to consumers. It's holding up the process for opening up facilities. And so what the bill does is it allows, in certain circumstances, the owners to instead advertise by other commercial means that are reasonable. The owner wants people to show up for a sale too, as it may drive up the amount of money that will go for the items in a sale. And so most of these are done online. And so the process, the legal organ, is something that's just holding up the sales. With that, happy to take any questions.
Recognize Senator from the 49th.
Thank you, Mr. President. Senator Yield?
Yes, sir.
Did you say self-storage or safe storage?
Self-storage. Self-service storage.
Thank you. Thank you. You've been up here several
Do
times.
I further yield? Yes, I do.
I'm sorry. Do you
Yeah.
Senator further yield?
Yes, sir. Yes, sir.
You recognize I'm new at this.
Yes, sir.
Do you further yield?
I know you're a freshman. It's okay. Yes, sir.
You've been up here several times today. Wouldn't you agree?
Many times. Yes, sir.
Are you running for office?
Not right now. No, sir.
Okay.
Will I be
that's
later?
That's not what we've been told, but
yeah.
But okay.
Maybe later.
Excuse me. Are you intending to run for office?
Which office?
Does the senator, if you got to ask him if he yields first, Senator.
Senator, do you yield?
I'll yield for a series of questions.
Do you intend to run for further office?
One day, possibly. I enjoy what I do here, and if the people want to send me back here, maybe I'll run for that, or maybe after prayerful consideration with my family, I'll decide to run for other things. But for now, Mr. Leader, I intend to serve this rest of this day, however long that is, and all day Friday with you.
Senator, you don't have to answer those questions. Hop out of the well.
I should.
Thank you, Senator.
Thank you. Good job.
No more questions. I know you are.
Okay. I'll yield the well.
You're going to be up like 4 more times before the night's over with. So, do any other senator wish to speak for or against the measure? Senator from the 53rd, for what purpose do you rise?
Mr. President, I ask for unanimous consent under pursuit of Rule 5-1.8 to be excused from voting on House Bill 131.
Wow. 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 I didn't think there was anything you scared of there, Mountain Man. Is there objection? Not objection. Senator excused. Are you serious? Does any speak for or against the measure? Chair hears none. Is there objection to the question being ordered? Chair hears none. Previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. Senator, what purpose does the senator from the 6th rise? State your inquiry.
Is my mic on? There we go. Is it not true that with the senator from the 53rd abstaining, this bill has a chance of passing unanimously?
Has a chance to pass what?
Unanimously.
I think the senator knows what he speaks. On the passage of the bill, the yeas are 54 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 20th.
Thank you, Mr. President. I ask for unanimous consent to remove House Bill 630 from the table.
Secretary, read the caption.
House Bill 630 by Representative Weiner, the 121st, and others, bills being titled Act to amend Chapter 47 Title 43, the OCGA relate to used motor vehicle and used motor vehicle parts dealers, so as to remove the used car division of the used parts division of the State Board of Registration of used motor vehicle dealers and used motor vehicle dealers parts to confer and for other purposes. Mr. President, that completes the order.
Is there objection? No objections. Secretary, finish the caption.
House Bill 630 by Representative Weiner, the 121st, and others, bills being titled Act to amend Chapter 47 Title 43, the OCGA relate to used motor vehicle and used motor vehicle parts dealers, so as to remove the used car division and the used parts division of the State Board of Registration of used motor vehicle dealers and used motor vehicle parts dealers, to confer the powers and duties of such divisions to the board, to revise the membership of the board, to revise the powers and duties of the board, to revise and clarify provisions related to the applications for and the requirements for licenses, to revise provisions related to the change of location by licenses, and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass by substitute. Respectfully submitted, Senator Cowser, Chairman. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following substitutes. It's House Bill 630, bill to be titled Act to amend Chapter 47, Title 43 of the OCGA related to used motor vehicle and used motor vehicle parts dealers, so as to remove the used car division and the used parts division of the State Board of Registration of used motor vehicle dealers and used motor vehicle parts dealers, to confer the powers and duties of such divisions to the board, to rise the membership of the board, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 20th.
Thank you, Mr. President. House Bill 630 came out of the joint House and Senate Blue Ribbon Study Commission we had on occupational licensing. I know, like me, you all have had a lot of calls from constituents frustrated with the onerous process of getting a license and renewing licenses. So this is another attempt, one of several bills that have come out of that committee. I want to thank Chairman Tillery, chaired it for the chairman for the 19th, chaired it for the Senate, and the senator from the 2nd was on the committee. This is part of Lieutenant Governor Jones's red tape rollback, So the other bill, we passed the big bill last week, which was House Bill 579, and the other bills are going to be more industry specific and more targeted towards certain licensing boards. This one is for the used motor vehicle and used motor vehicle parts dealers. It's got some definitions. It combines the two divisions of the board. It decreases the size of the board and eliminates board seats. It cleans up outdated information regarding the initial appointments to the board, removes the cap on the number of board members that may be appointed from a single congressional district. It gives the Professional License Board Division Director the authority to administer licenses to applicants who meet the licensing requirements. It codifies language from the Georgia Supreme Court's decision in Jackson versus Raffensperger. Authorizes the board to establish minimum requirements and standards for an established place of business. Restructures the licensing requirements to enhance clarity and usability for applicants. Allows the fee for the temporary site permit to be set through the board rule. Authorizes the board and division director to establish fees for change of location licenses, and allows the board to discipline licensees who fail to submit a change of location. It's a good bill. It'll make life easier for our used car dealers and motor vehicle parts dealers while ensuring the protection of the citizens of Georgia. I ask for your favorable vote on this bill. Thank you, and I'm happy to answer any questions if there are any. Otherwise, I'll yield the well. All right, thank you.
You did great, Senator. Is any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Question is on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1, and this bill has received the constitutional majority and therefore is passed. Recognize Senator from the 20th.
Mr. President, I ask for unanimous consent to remove House Bill 635 from the table.
Secretary, read the caption.
House Bill 635, by Representative Weedower, the 121st, and others, a bill to entitle an act to amend Chapter 41 and Title 43, the OCGA, related to residential and commercial general contractors, so as to revise provisions related to state licensing board for residential and commercial general contractors, to revise and clarify qualifications for licensure as a residential or commercial general contractor, to revise provisions related to examination of applicants, to revise provisions related to the refusal to grant a license, revocation of a license, or other disciplinary action of the board, to provide related matters, to repeal looking laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
House Bill 635, by Representative Weedower, the 121st, and others, a bill to entitle an act to amend Chapter 41 and Title 43, the OCGA, related to residential and commercial general contractors, and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted, Senator Cowser, Chairman. Mr. President, that completes the order.
Recognize Senator from the 20th.
Thank you, Mr. President. Another licensing bill. This deals with residential and general contractors. House Bill 635. A lot of work on this from the House and Senate and the Governor's office and the Secretary of State's office. It eliminates term limits for board members because they need some experienced board members to be on there for the institutional knowledge. Expands eligibility for the public building official position to allow them to serve on the board if they're appointed. eliminates the prior authorization requirement for the examination. This is a big one. This will reduce the financial burden on applicants. They can take the exam and know whether, if they can't pass the exam, they know not to pay the application fee. So it'll save them that added expense, and it increases the efficiency for the professional licensing board not to have to review applications for people that can't pass the exam. Removes the limit on the number of exams an applicant may take before they pass it. Eliminates subjective language. It clarifies. There's a lot of subjective decisions that are having to currently be made. It makes it a lot more clear and objective, not subjective. It's a really good bill. I'd be happy to answer any questions. I could go on and on about this exciting bill, but I don't. I ask for your favorable vote. Thank you.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. All right, we're going to take a 10-minute break. We're almost done. We're going to take a 10-minute break. We're waiting on something from the house. So y'all stretch your legs and get you a snack. And we're almost finished. Thank you. Senate, come back to order. Recognize the senator from the 42nd.
Mr. President,
This is exciting.
I ask unanimous consent that House Bill 177 be taken from the table.
Secretary, read the caption.
House Bill 177 by Representative Cooper, the 45th and others, bills being titled enacted amend Title 19 of the Official Code of Georgia Annotated related to domestic relations as to provide protection for household pets in both family violence and dating violence protective orders, to provide for definition and an exclusion, to provide for related matters, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
Is there objection? Hearing none, Secretary, finish the caption.
House Bill 177 by Representative Cooper, the 45th and others, bills being titled enacted amend Title 19 of the OCGA related to domestic relations as to provide protection for household pets in both family violence and dating violence protective orders, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, Chairman. That completes the order, Mr. President.
Recognize the senator from the 42nd. Not like this bill, Senator.
Thank you, Mr. President. House Bill 177, this deals with family violence, TPO, protective orders, and dating violence protective orders. And currently under the law, a judge can award personal property to somebody in these situations. Someone that's been a victim of family violence can get personal property awarded to them in addition to a protective order. What this bill does is it adds household pets as property that can be awarded in these type of proceedings. This is important because what we hear from advocates is sometimes someone that's abusing a spouse will use that pet, hold that pet over their head, threaten to hurt that pet, threaten to keep them from that pet as a way to intimidate them. What this bill does is it confirms that someone that has a household pet that's being used against them in those situations, they can actually have that order by the judge awarded to them, or have it ordered that someone won't remove that pet or hurt that pet as well. Happy to take any questions.
You do have a question, Senator. Senator from the 13th.
Senator Yield,
Yes, sir.
could you please one more time go over the issue about how the dog is separated from the two people, if in a conflict, please?
So when there is a family violence protective order being heard, a judge has different things they can order under current law in addition to a protective order saying, stay away from me, give me the house. They can award certain things to somebody. This confirms as part of the personal property that can be awarded is the dog, the cat, a household pet can also be given to the person that is a victim of a TPO, victim of family violence or stalking or dating violence. And to correct one thing I said, it does not include the stalking TPO. So it'd be dating violence or family violence. It also confirms that a judge can order that the defendant not harm a household pet or not remove a household pet from a home when they are leaving.
Another question, please.
Yes, sir.
Well, if in that case, will the court be able to seize that animal and get it to a qualified home?
The bill doesn't deal with the ability to seize an animal, so the court would be limited to giving the animal to one of the two parties. And so this is not a situation where a court would come in and remove an animal. Instead, a court could say, you, the victim of family violence, get the dog to go with you. Or you, the person, the perpetrator, can't harm this pet as part of the order. Again, I mean, it's something that when people sometimes hear about the bill, they may laugh at first and why are we dealing with dogs and cats and pets? But this is something that real people deal with, and they're victims of violence. And we all know if you have a pet that's part of your family, this is something that can be used to intimidate you and prevent you from seeking a protective order in a case.
Thank you, Senator.
Thank you.
Recognize the senator from the 30th.
Does gentleman yield?
Yes, sir.
So lines 37, 38, so a working animal or sport animal, they cannot be harmed by a spouse that may be going through through the TPO?
So lines 37, 38?
Yeah, it shows the ones that I believe that cannot be brought into this.
So we're trying to make sure that these are truly household pets. And so we confirm that in the situation of a TPO, you're not going to have livestock or commercial animals be the subject of that. Now, in a divorce case, they are. That's something that in a divorce case, a judge would order somebody to get the cows or get value for cows, for example. But looking at TPO, sticking to the intent, the whole goal of a TPO is to stop family violence and protect somebody from future family violence or dating violence. We expanded a couple years ago. And so we're just limiting it to including household pets as something the judge can also deal with in these cases.
Thank you, sir.
I ask for your support of House Bill 177. Thank you.
Does any other senator wish to speak for or against this measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill vote yea. Opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Recognize Senator from the 21st.
Mr. President, I ask unanimous consent to lift House Bill 156 off the table.
Secretary, read the caption.
House Bill 156 by Representative Jones of the 25th and others, the bill to be entitled an act to amend Chapter 1 and Title 6 of the Official Code of Georgia annotated related to general provisions relative to aviation, so as to provide for the Department of Transportation with authority over preventive ports, to provide for definitions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
House Bill 156 by Representative Jones of the 25th and others, the bills will be entitled an act to amend Chapter 1 and Title 6 of the OCGA related to general provisions relative to aviation, so as to provide for the Department of Transportation with authority over vertiports, to provide for definitions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Transportation recommends that this bill do pass. Respectfully submitted, Senator Dolezal, Chairman. Mr. President, Senator Hodges III and others offered the following amendment number 1 to amend House Bill 156 by inserting after definitions on line 3 the following: to amend Code Section 48-13-50.2 of the OCGA relative to definitions relative to excise tax on rooms, lodgings, and accommodations, so as to revise the term of the term tourism product development to include air service product expansion at carrier airports and for other purposes. Mr. President, that completes the order.
Recognize the future United States Treasurer.
Hey, thank you, Mr. President. Senators, I bring before you House Bill 156. For those of you that are my age, you remember the Jetsons and flying airplanes. Well, that's what we've got here. We are going to establish the foundation by which Georgia transportation will incorporate personal and small commercial air travel. This bill really just does two things. It defines vertiports as areas designed for landing, takeoff, and the servicing of EVOTLs. And then it also expressly incorporates that vertiports as landing fields where GDOT has jurisdiction. That's all this bill simply does. It does that for these new aircraft that can fly you. They're going to be almost like air taxis. So we need to get ready to get in an air taxi. They're building these things. Archer is, I think, in Conyers. So it's going to be a great industry, and I'd ask for your support, Mr. President. I'll yield for questions, or I will yield the well.
You do have one question, Senator. I recognize the Senator from the 27th.
Yes.
Thank you, Mr. President. The Chairman yield.
Yes.
Earlier, I asked a question of the Chairman from the 19th relative to your morning routine, and he indicated that you have a special morning routine. Is that true?
Yes, I do.
Would you, I believe this is perhaps your last official bill, you may have a special action that comes, but would you maybe allow the Senate to see exactly how it is that you do this morning routine as you prepare for your day?
Well, my wife asked me to do this every morning. She loves this, and I look at her, and then, I really look in the mirror, and what do I see? A good-looking stud named B.L.B. I yield the well.
Senator from the 3rd, you get to follow that.
Thank you, Mr. President. I'm just going to hope that I can ride his coattails with my amendment. This is a simple amendment to his bill. It basically adds air service product expansion at air carrier airports to a list of legal uses of hotel motel sales tax dollars. In Glenn County, we are interested, our CVB is interested in increasing air service at our local airport in Brunswick. We'd like to add some new flights, maybe possibly a new carrier. And we'd like to use, somebody had the great idea to use hotel motel sales tax dollars to do that, and then somebody had the good sense to look at the law and found that we couldn't. So this amendment to the Stud Rocks bill will remedy that. So I ask favorable consideration. And
you do have a couple questions, Senator.
Okay.
Recognize Senator from the 48th.
Thank you, Mr. President. Does my seatmate yield?
Your sweetmate yields.
Senator, earlier this morning, you and I had a conversation about an app called Instagram.
Oh, God.
And there was a profile, Georgia Gossip Girl, and something about every leaked secret, every not-so-subtle dig, and revealed you as the actual source. And I was wondering if you could just speak to that.
The only thing that I will say is that it's not the first time I've been outed.
Recognize Senator from the 24th.
Does the senator yield for a question?
He certainly does.
Senator, when you get up every morning and you look in the mirror, what do you see and what do you say?
To my good friend from the 24th, when I get up in the morning, I can't see. And I'll bet the senator from the 21st can't see very well either. I yield the well, Mr. President. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of amendment number 1, authored by the senator from the 3rd. Is there objection? Without objection, amendment number 1 is adopted. Is there objection to agree into the report of the committee which is favorable to the passage of the bill? Chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Beach, you on a roll, baby. Beach Bucks. Recognize the senator from the 32nd.
Thank you, Mr. Chair. I ask for unanimous consent to remove House Bill 197 from the table.
Secretary, read the caption.
House Bill 197 by Representative Hawkins of the 27th and others, bill to be entitled an act to amend Code Section 33-46-6 of the OCGA related to requirements for certification, utilization of nationally recognized accreditation standards, and website identifying nationally recognized accreditation entities, so as to detail the effort that shall be made by treating healthcare provider to respond to a private review agent or utility review entity's attempt to reach such provider to discuss the patient's care and for other purposes. Mr. President, that completes the order.
Hearing none, Secretary, finish the caption.
House Bill 197 by Representative Hawkins of the 27th and others, bill to be entitled an act to amend Code Section 33-46-6 of the OCGA related to requirements for certification, utilization of nationally recognized accreditation standards, and website identifying nationally recognized accreditation entities and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Brass, Chairman. Mr. President, the Senate Committee on Rules offers the following substitute to House Bill 197, a bill to be entitled an act to amend Code Section 33-46-6 of the OCGA related to requirements of certification, utilization of nationally recognized accreditation standards, a website identifying nationally recognized accreditation entities, so as to detail the effort that shall be made by treating healthcare provider to respond to a private review agent or utility review entity's attempt to reach such provider and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 32nd.
Thank you, Mr. President. This bill has to do with prior authorization, and the House had a bill that adds a callback procedure. If the insurance company calls the doctor and can't get hold of them, they're not available at that moment. It gives them a way to connect and take some of the burden off the doctor. In addition, it incorporates Senate Bill 5, which is the gold card bill about prior authorization that we passed previously. Happy to answer any questions.
You have no questions, Senator.
Thank you. I yield.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Is there objection to the main question being ordered? Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 23rd.
Thank you, Mr. President. I request that House Bill 127 be removed from the table.
Secretary, read the caption.
House Bill 127 by Representative Cox, the 28th and others, bill to be entitled an act to amend Part 4, Article 17 of Chapter 2 of Title 20, those CGA related to sick, personal, and maternity leave for teachers and other school personnel, so as to increase from 3 to 5 the number of accumulated sick leave days teachers or other school personnel may take to each school year for personal or professional reasons, derived for related matters, repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 23rd. Oh, there was objection? Okay, got objection. All those in favor of pulling the bill from the table will vote yea. All opposed, nay. Secretary, unlock the machine. Recognize Senator from the 14th.
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, just like preventative medicine, diet, and exercise, isn't this vote the easiest that this vote ever gets right now, Mr. President?
Red or green's always a choice, Senator.
Yes, sir.
On the motion to remove from the table, the yeas are 33 and the nays are 21. And Senator, the well is yours. Stand by, Senator. We got to finish reading the caption. Stand by. Secretary, read the caption.
House Bill 127 by Representative Cox, the 28th and others, the bill to be entitled an act to amend Part 4, Article 17 of Chapter 2 of Title 20, those CGA related to sick, personal, and maternity leave for teachers and other school personnel, so as to increase from 3 to 5 the number of accumulated sick leave days for teachers and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Hickman, Chairman. Mr. President, the Senate Committee on Education and Youth offers the following substitute to House Bill 127, bill to be entitled an act to amend Article 1 of Chapter 1 of Title 20, those to GA related to general provisions relative to education, so as to provide that local education agencies and post-secondary institutions shall not promote, support, or maintain any programs or activities that advocate for diversity, equity, and inclusion, strive for exceptions, strive for sanctions, strive for definitions, strive for related matters, strive for effective date and applicability to repeal conflicting laws and for other purposes. Mr. President, the minority part to House Bill 127 has been attached, and that completes the order.
Senator from the 23rd.
Good evening, colleagues. It's good to close out the night on a lively debate and discussion. I want to bring you House Bill 127. This is a bill about equality. It's about merit. It's about performance. It's about ability. It's about work ethic. It's about achievement. Every Georgian deserves an opportunity to achieve without being discriminated against. I hope we can all agree on that. I want to begin by making a few comments, and we'll walk through the bill, and I'm sure we'll have some conversation. You'll recognize the language in House Bill 127 as a modified version of Senate Bill 120. It was authored by the senator from the 16th. That passed out of the Higher Education Committee on March the 3rd, but was not called up for consideration on crossover. Education in Georgia must now address a concept which, perhaps while well-intentioned, is fundamentally discriminatory. In the academic environment, diversity, equity, and inclusion, those processes and programs base decisions like admissions, employment, promotion, work assignments, resource allocation, and other fundamental operational decisions in whole or in part on race, color, sex, ethnicity, national origin, gender identity, or sexual orientation. These decisions should be based on merit, on performance, on ability. In Georgia, we've experienced more highly qualified applicants fail to be admitted to an academic institution of their choice in deference to less qualified applicants because of their ethnicity. In Georgia, we've seen cases where employees and faculty are required to sign diversity statements indicating their conformance to an ideology that provides special consideration and benefits based on race. We've developed curriculum, programs, degrees, courses, all at taxpayer expense to promote and promulgate the discriminatory ideology of DEI. The Senate substitute that we here today see as House Bill 127 seeks to address these issues and problems. I want to make you aware of a recent article in the Journal of Higher Education. The Journal of Higher Education indicates that as of February 2015, 119 bills have been introduced in 29 states to curtail DEI initiatives at public colleges. They were there to ensure that all students were treated equally. These initiatives ban the use of training or the use of diversity statements in hiring and promotion, in identifying in using identified preferences in hiring and admissions in mandatory classes. Legislation has been officially passed in 12 states: Alabama, Florida, Idaho, Indiana, Iowa, North Carolina, North Dakota, Kansas, Tennessee, Texas, Utah, and Wyoming. On January the 20th, the President of the United States issued an executive order banning the use of illegal and immoral discriminatory programs. And he ordered the termination of all discriminatory programs, including DEI and diversity, equity, and inclusion and accessibility. Let's look at House Bill 127. I'll briefly go through the bill. It's only about 66 lines, so I don't think it'll take a long time to do that. Section 1 is basically some definitions. We define local educational agency. This is our secondary school system. If you look at the reference title, it means any local school system and any charter school that is subject to state funding. If you look at number 2, we define multiple occupancy restrooms and changing areas to ensure that those who use those facilities are protected from members of something other than the designated sex using them. This includes restrooms, locker rooms, changing rooms, and shower rooms. And finally, on line 25, we define post-secondary institution as a unit of the University System of Georgia or a unit of the Technical College System of Georgia. The essence of the bill is in lines 28 through 30. No local educational agency or post-secondary institution shall promote, support, or maintain any programs or activities that advocate for diversity, equity, and inclusion. And then in lines 30 and following through line 52, we define what diversity and equity and inclusion means. This includes, notice that section B, number 1, subparagraph 1, any effort to promote a different treatment or provide a special benefit to individuals based on race, color, sex, ethnicity, national origin, gender identity, or sexual orientation. So we are banning the use of any program that promotes a different treatment or a special benefit based upon these protected classes. Number 2, in line 34, promote or promulgate policies and procedures designed or implemented to reference race, color, sex, ethnicity, national origin, gender identity, or sexual identity. So you can't reference them in your inability or ability to discriminate. Number 3, you cannot promote or promulgate any training, programming, recruitment, retention, or activities that would provide preferential treatment. Number 4, you cannot promote or promulgate any training, programming, or activities that are implemented with reference to. And then finally, in number 5, line number 43, we have a most important section. Post-secondary institution. A post-secondary institution cannot have any effort to promote as an official position of the post-secondary institution any particular widely contested opinion referencing unconscious or implicit bias, cultural aberrations, allyship, gender ideology or theory, microaggression, group marginalization, anti-racism. Notice that is a capital A, not a small a. It's a noun. We'll discuss that if you like. Systemic oppression, social justice, intersectionality, neopronouns, heteronormality, disparate impact, racial privilege, sexual privilege, or any similar or related formulation. 49 through 52 is a acknowledgement that we have certain interscholastic and intercollegiate activities that are indeed based on sex. So this bill does not prohibit girls' sports or boys' sports. It actually ensures that they can be defined that way. So male sports versus female sports. 53 through 64, 53 through 60 deal with compliance. If a post-secondary institution violates these provisions, they shall be subject to withholding of state funding or state administers federal funding, including funds that provide the post-secondary institution directly with funding such as scholarships, loans, grants, and those types of things. And then Section C on line 58 deals with the secondary system. The State Board of Education shall be authorized to withhold a portion of state funding to any local education agency that violates these principles. Section F on line 61 makes sure that this is not subject to a waiver. We have a number of waivers in the secondary education system. Most importantly, line 65. Nothing in the code section shall be constituted to prohibit compliance with any applicable state or federal discrimination law. Sections 2 and 3 are cleanup language, but ladies and gentlemen, that is House Bill 127. I hope that you will agree with me that there's no place in Georgia for discrimination. I want to take one last minute and talk about equality. Let's talk about equality. Equality means equal opportunity. As you study DEI literature, often there's a reference to ensuring that everyone can see over a wall. Tall people can easily see over the wall. Modest-sized people have a harder time. Shorter folks, unfortunately, can't see over the wall. And so DEI, I recognize that might be a bit of an offense to the senator from the 6th. Shouldn't be. Because you've overcome the height disadvantage. And you've overcome the height disadvantage not by being provided a special treatment, but by being provided skills and tools to overcome a height disadvantage. The senator from the 31st and I, and the senator from the 6th, make that the 8th. Was it the 6th? It's the 6th. Had an opportunity this week to visit my alma mater. And the senator from the 31st alma mater. We went to a football practice, Mr. President, at Georgia Tech. They were trying to figure out how to play football like the Bulldogs do. But I noticed that on that team, there were large, massive linemen. And there were short, fast running backs. At the end of the day, they all were given an opportunity to play. And they all achieved that opportunity through hard work and perseverance. So I would suggest to you that equality is what we seek. Equity would say results are standardized. That's not the objective of this policy or the policy in Georgia. So I'm happy to take questions, happy to yield the well.
Recognize senator from the 26th.
26. My good friend.
I used to be your friend.
You're still on.
Do you? With the senator here. Do you yield, Senator?
Absolutely.
Do you believe what you just read?
I do.
Do you really?
I appreciate the question, Senator, but I believe that equality is our goal. And that to discriminate against a student and not allow them to be admitted to a university because of their ethnicity. The courts have ruled in 2023 that Harvard and other schools utilized ethnic bias and denied access to more qualified students. I would not want that to happen in Georgia.
Will the gentleman yield?
Certainly.
Isn't it true the plane crash over the Potomac was blamed by the president on DEI? DEI, that's the same thing you were talking about. It was blamed on DEI. Isn't that what the president said?
I believe there were news reports to that effect, and I believe the issue was whether or not the operators of that aircraft were promoted based upon their sex, not on their ability. That has not, to my knowledge, been proven.
The gentleman is old enough, isn't it true, to read the history books that talked about World War II.
Absolutely. My father fought in World War II. I remember his stories well.
And, well, isn't it true? When the bombers couldn't make it back home, got shot down, it was those Tuskegee Airmen that led them to all those victory flights.
They did a brilliant job, and we're proud of the Tuskegee Airmen. Every Tuskegee Airman earned that privilege based on their ability, not on their color. Remember, we have to provide them the opportunity.
No. Senator, isn't it true? The same guy that talked about DEI was fined for not letting folks stay in an apartment, and he called them DEI. Isn't that true?
I'm sorry, Senator, I'm not familiar with that allegation. I would suggest to you that this bill is addressing the banning of DEI in the educational environment in Georgia, both at the secondary and the post-secondary level. Happy to yield for other questions.
You can't answer no more.
Thank you, Mr. President. I'll be happy to yield the well.
You're free to do that, Senator.
I'll be happy to yield the well.
Senator's yielding. Secretary, go ahead and read the amendments.
Mr. President, Senator Estevez of the 35th offered the following amendment number 1 to amend the Senate Committee substitute of House Bill 127 by striking widely contested from line 44, striking cultural appropriation allyship from line 45, and striking intersectionality and desperate impact from line 47 by striking violates and replaces it with is found by a court to have violated on line 53 by striking violates and replacing it with is found by a court to have violated on line 60. Mr. President, Senator Estevez of the 35th offered the following amendment number 1A to amend Amendment 1 to the Senate Committee substitute of House Bill 127 by striking cultural appropriation from line 2 by striking intersectionality and from line 3. Mr. President, Senator McLaurin of the 14th offered the following amendment number 2 to amend the Senate Committee on Education and either substitute to House Bill 127 by inserting after line 48 the following. B.1, nothing in subsection B of this code shall be construed to prohibit a local education agency or post-secondary institution from voting as an official position that 1, evolutionary biology is a scientific fact, 2, slavery was the primary or major contributing cause to the American Civil War, or 3, the Holocaust occurred. Mr. President, Senator Parent of the 44th and Jones of the 22nd offered the following amendment number 3 to amend the Senate Committee on Education and Youth substitute to House Bill 127 by deleting the quotation marks at the end of line 66 by inserting the following after line 66. H, beginning July 1st, 2025, no public elementary or secondary school in the state shall use the Confederate States of America battle flag or any other name, image, or likeness which represents a rebellion against the United States of America or a movement that has been called for the dissolution of the United States of America. Mr. President, Senator Jackson of the 41st and Jones of the 22nd offered the following amendment number 4 to amend the Senate Committee substitute of House Bill 127 by inserting on line 67H, nothing in this code section shall be construed so as to prohibit any fraternities and sororities from maintaining gender-exclusive membership. Mr. President, Senator Halpern of the 39th offered the following amendment number 5 to amend the Senate Committee substitute to House Bill 127 by inserting a new section C on line 49 that reads, and inserting the following. This subsection shall prohibit use of prior familiar admission or attendance as a criteria for admission and relettering all the following sections accordingly. Mr. President, Senator Mangum of the 55th and Jones of the 22nd offered the following amendment number 6 to amend the Senate Committee substitute to House Bill 127 by inserting after line 48 the following. Nothing in subsection B of this code section shall be construed to prohibit a local education agency or post-secondary institution from promoting as an official position that the Confederate States of America was a nation separate and apart from the United States of America, founded in unconstitutional rebellion. Mr. President, Senator Harold of the 40th offered the following amendment number 7 to amend the Senate Committee substitute to House Bill 127 by inserting on line 48 after sexual privilege the following: diversity, equity, and inclusion provisions. Mr. President, Senator Kemp of the 38th offered the following amendment number 8 to amend the Senate Committee substitute to House Bill 127 by striking line 48, anti-racism. Mr. President, that completes the order.
Recognize the senator from the 26th. Yes, sir, you can. You're up. It's your on deck.
Thank you, Mr. President. You know, the gentleman from the 23rd, I am appalled that you even have the unmitigated gall to even bring such a thing into this body. I came from the 60s. And you're old enough to know what happened back then. We had B&W for a water fountain. We had B&W for restrooms. B&W in the waiting rooms when you caught the trains. We fought those battles back then. And because we have a man that told you on day one that he would be a dictator, and that's what he's trying to be, on day one, and you bring this kind of mess up here, after all the battles that we've fought, black and white, in the South, you gonna call DI athletes at Georgia? You gonna call them DI athletes at Georgia Tech, Georgia State, Kennesaw? I thought we had got past that and deal with one another on various issues and not try to relive the Civil War. Reliving it. You're old enough to know what it was about. I'm old enough to know about it. I experienced it. And now you have the nerve to come in here with this mess. You're drinking Trump Kool-Aid. And what's happening in this country, and they're going to show it to you. They are protesting everywhere called the tide. Social Security. People don't know where they're going to get the benefits. They tired. Veterans who put their life on the line for this country. And you talk about privatizing them. They're tired. And then you have the mitigated goal to bring something like this. When we fought these battles over, and now you're trying to start fighting them again. But I'm telling you, I ain't going back. I'm not going back. I am not going back. I try to get along and work with everybody, but I'm not going back. I'd rather be 6 feet in my grave than go back.
Recognize Senator from the 2nd.
Thank you, Mr. President. This is one of those bills, colleagues, that had John Q. Public and Jane Q. Public had the opportunity to come and debate and have a robust debate about DEI. I don't want to say DEI. I want to talk about diversity, equity, and inclusion. And I thought about, in discussing diversity and discussing equity and discussing inclusion, if there is a need to ban DEI, then what is the opposite to diversity? Well, the opposite to diversity is uniformity. And to be uniform means that you lack any other options for anyone to be different, to look different, to talk different, to walk different, to be different. Then I thought about, well, what is the opposite of equity? Well, the opposite of equity is inequity. And then I thought about, what is the opposite of inclusion? Well, the opposite of inclusion is exclusion. Now, my colleagues may not quite understand where I'm coming from because you don't know what it's like to be first if you've never been last. And so when the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This was a promise that all men would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. But when the architects wrote that promise, there were some folks that could not benefit from that promise. And that's why we have diversity of thought, diversity of personhood, because we did treat some folks like second-class citizens. And when I look at this bill and we talk about educational programs and the post-secondary institution shall promote, support, or maintain any programs or activities that advocate for diversity, equity, and inclusion, and it lists a group of definitions. So then I had to do the math because I am a public school graduate, and when I look back on the math, it had only been 61 years since the Civil Rights Act of 1964 had been passed. It wasn't until 1971 that the city of Savannah would integrate public schools and have a federal monitor for 20 years because the school district chose to remain segregated for another 20 years. It wasn't until 1996 when the city of Savannah would elect its first African-American mayor because representation had not always been granted. But then I thought about maybe if I just skip back from 1964 and I'm leaving 2025, maybe I would get down to 1865. And in 1865, General William Tecumseh Sherman would march, burning every plantation on his way from Atlanta down to Savannah, but he would issue Sherman's Field Order number 15 that said, basically on all 400,000 acres of confiscated Confederate land, it would be divided by 40 acres for every African American to get 40 acres and a mule. That was equity. Well, we know that President Lincoln was assassinated and that promise was not delivered, so that equity promise never came to for those folks that had been oppressed. And so while we're talking about what is diversity, what is equity, and what is inclusion, colleagues, it is more than just what you see on this sheet of paper right here. It is a fundamental understanding of the folks that have fought, bled, and died, especially in the civil rights movement, to make sure that African Americans could have an equal footing or a place. And so when I read words in the bill that talk about you cannot promulgate policies or promote policies or procedures implemented with reference to race, color, sex, ethnicity, national origin, gender, identity, or sexual orientation, colleagues, I wonder what made us so nervous about having folks that were diverse. Because last time I checked, the state of Georgia does not have any anti-discrimination laws on the books. That's why we had to repeal the citizens arrest law. Because if you think about the tragedy that happened and you watch how the civil justice system unfolds, you can quite find that folks are treated very differently. It's not 100 years or 50 years. You can just look back at last year. You can look back at the amount of folks that just don't like you because of the color of your skin. That's why we have diversity, equity, and inclusion. So if I could prick the moral conscience of every colleague in this room, I would just ask you to think about how many times have you looked to work with a diverse vendor? How many times have you done intentional business with somebody that didn't look like you? How many times have you gone out of your way to go into a community that wasn't your community? How many times have you gone to help folks that didn't look like you? And so then I thought, well, maybe my faith could compel my colleagues, and I was drawn back to a scripture, and I want to share it with you. It was Luke chapter 10, beginning at verse number 30. And Jesus said a man was going down from Jerusalem to Jericho when he was attacked by robbers. They stripped him of his clothes, beat him, and went away, leaving him half dead. A priest happened to be going down the same road, and when he saw the man, he passed by on the other side. So to a Levite, when he came to the place and saw him, passed by on the other side. But a Samaritan, as he traveled, came to where the man was, and when he saw him, he took pity on him. He went in and bandaged his wounds, pouring on oil and wine. Then he went and put the man on his own donkey, brought him to an inn, and took care of him. The next day, he took out 2 denarii and gave them to the innkeeper and said, look after him. He said, and when I return, I will reimburse you for any extra expense you may have. Which of these do you think was a neighbor to the man who fell in the hands of robbers? The expert in the law replied, the one who had mercy on him. Jesus told him, go and do likewise. So as we talk about diversity, equity, and inclusion, I'd like to come back to the bill because I want to put a bow on it. Line 37 says, any effort to promote, promulgate any training, programming, recruitment, retention, or activities designed or implemented with preferential treatment of any race, color, sex, ethnicity, national origin, gender identity, or sexual orientation over another. Any effort to promote or promulgate any training, programming, or activities designed or implemented with reference to race, color, ethnicity, gender identity, or sexual orientation. And so you're saying it would be illegal to tell folks about what happened to African Americans. It would be illegal to talk about history. It would be illegal to accept the reality of the painful past of folks that may not look like everybody in this room. And so when we talk about anti-racism, or systemic oppression, or social justice, I would remind my colleagues the night before his assassination in April of 1968, Dr. Martin Luther King told a group of striking sanitation workers in Memphis, Tennessee, that we have to give ourselves to this struggle until the end. Nothing would be more tragic than to stop at this point in Memphis. We've got to see it through, because Dr. King believed the struggle in Memphis exposed the need for economic equality and social justice. That's why he wanted to highlight his Poor People's Campaign nationally, because the fight for economic equality and social justice are not just simply diversity, equity, and inclusion. And so, my colleagues, I just ask you this question. Have you given yourselves to the struggle to eradicate different identities and people of different thoughts and ideas? Because, again, you don't know what it's like to be first until you've ever been last. In the history of the United States of America, we have only appointed 3 African Americans to the highest court in the United States. Why is that? And so as I continue to move through this bill, just to highlight the further issues with the bill, it just continues to talk about having any program, and you would violate this subsection and we would withhold state funding or state-administered federal funding. Well, we see what happened when DEI rolled out at the federal level. The Tuskegee Airmen were removed from the Department of Defense website. We saw that the first major general from Vietnam, an African American to receive the Medal of Honor, was removed from the website. We see that Jackie Robinson was removed from the website. We see this over and over and over again, because the opposite of diversity is uniformity. And when the architects of our republic wrote those magnificent words to the Declaration of Independence, folks who looked like me didn't have the opportunity to partake in that promise. So Dr. King said, we're all tied together in an inescapable network of mutuality, that whatever I am, you ought to be, and until I can be what I ought to be, you can't be what you ought to be. And so the idea that we would ban diversity, equity, and inclusion is simply nothing more than smoke and mirrors. Because if you truly look at the merits of this bill, what other opportunities do we withhold funding? We never withheld funding from any post-secondary institution if they denied someone entrance based on their race, their ethnicity, their color, creed. We've never withheld that funding. We've never passed any laws or legislation like that. And so now we say, but if you talk about diversity, equity, and inclusion, we're going to hold the money back. Well, what about the folks that paved the way? We're going to say that, oh, well, now we can't talk about race. It makes me uncomfortable. Well, that is a dark past of history that we too must accept. You cannot sweep history under the rug. You have to accept the things as though they have happened. But the idea that you would limit the discussion based on this because it makes you uncomfortable, colleagues, I think we are better than this bill. Just because somebody says something don't make it true. Just because somebody said something, I've never understood how DEI can be classified as didn't earn it. And when you talk about things will be based on merit, that is an ideology that the person who makes the determination of what is merit, they get to determine what is merit worthy. What is the merit? You can still have all the requirements and all the things checked. Like many African Americans, they checked the box and they were still denied entrance. They had all the criteria and all the qualifications and they were still denied a license. They had every opportunity to do everything and they were still denied. So it can't be about merit, because we already tried that before and merit didn't work for us. We tried merit time and time again and we were still at the bottom of the barrel. So clearly we had to have something to make some equity in this program. And so diversity, equity, and inclusion is just simply that, colleagues. It's an opportunity to bring people in that don't look like you. And if you don't look to see who the folks are that don't look like you and to see where their makeup happens to be, I wouldn't be the senator of the 2nd if it wasn't for the Civil Rights Act. Because my district under Section 2 is majority minority, majority black. The folks that send me to Atlanta happen to be majority black. And they chose to elect a representative. That's why you can't crack and that's why you can't pack. Because if this was truly all equitable, we wouldn't have those laws on the books and folks wouldn't be trying to pack folks in a district or trying to crack folks in another district. But as I close, Mr. President, time and time again, what a tangled web we weave when we seek to deceive. But colleagues, I just want you to know, if you vote on this bill, it'll be a referendum on how you view folks that don't look like you, how you don't view folks that may not think like you think, look like how you look. And colleagues, I think that's a slippery sliding slope. Anytime we pass laws like this, because the unintended consequence is just like when we were fighting to make sure that AP African American history would be treated the same way as European AP history. The state school superintendent couldn't even answer the question as to why it wasn't permitted. Had to have folks make phone calls, had to have folks write letters, do all of those things to include AP African American history. Even Governor Kemp himself sent a letter over to the state school superintendent to ask why AP African American history wasn't being treated the same as European history. Why the Attorney General sent a letter, had to ask the same question. So if it was all about diversity, equity, and inclusion, why last year did we have to go through all of that hurdle to ensure that AP African American history would be treated and taught the same as European history? My colleagues, where were you on that? Did you sit silently in your chairs and be duplicitous in the process, or did you say something about it? Because I remember I checked the roll call of people that sent a letter over to the state school superintendent asking a question about why the treatment was different. And so again, I just say, if it was about diversity, equity, and inclusion, we wouldn't be fighting right now to make sure that representation was equal for everybody. But you don't know what it's like to be first until you've ever been last. And if you've never been last, Mr. President, I don't know what to tell you, but I can tell you about some folks that have been last. I can tell you about some folks that have been first. I can tell you about some folks that did some amazing things. And as I take my seat for the last time, Mr. President, I'm reminded of that great sister named Fannie Lou Hamer that said, I'm sick and tired of being sick and tired. And Mr. President, I am sick and tired of being sick and tired. And I yield the well. Oh, well, Mr. President, there are questions. Let me take a few questions, because I don't mind.
Recognize the senator from the 28th. Recognize senator from the 14th.
Thank you, Mr. President. As my good friend from the 2nd yield.
I yield.
Senator, do you remember earlier this year when there was a tragic collision of a plane and a helicopter at a D.C. airport? You remember that episode?
I absolutely remember that. The senator from the 14th, I do.
Senator, further yield?
I further yield.
Senator, you remember that several officials in President Trump's administration, I think including the president himself, blamed the crash on DEI. Do you remember that?
I do remember that, Senator.
And Senator, do you yield for a couple more questions about that?
I do. I yield for a series from my good friend from the 14th.
Senator, at the time, was there any evidence of who even the pilots of the helicopter and the plane were when the president made these comments?
There was no evidence based on who the pilot or the co-pilot of either of the aircrafts at the time happened to be, but to make a statement about DEI from the former president was no indication that he actually had any factual basis to make that determination, but it was something that he just decided to spew.
Senator, not that we know the mind of the president directly, but is there any indication of why the president or some of his officials might have immediately blamed DEI or blame the crash on quote unquote DEI?
it was to further stoke, in my opinion, Senator, further division in this country, to have folks wondering, well, who were the pilots and what if they were of the D version of DEI and were diverse. And so when those pilots were not diverse, he never retracted the statement to say, oh, it's not DEI, because he didn't know who the pilots were.
Senator, and I want to be very clear, colleagues, that I don't think that everybody who says DEI in a derogatory way means this. But what is the concern that some people have about why people are using the word DEI and what they mean when they say that?
Well, Senator from the 14th, you know also well that when folks use the term now DEI, it is the new N-word to be derogatory, especially of those of African-American, African descent here in this country. And it is furthermore derogatory to say DEI and to classify that by saying didn't earn it. As you know, Senator from the 14th, I hold 3 degrees, and I believe that I'm very much educated, but I got to school on a thank you, Jesus, not cum laude, not magna cum laude, not summa cum laude, but thank you, Lord. And I was just glad that I got out of college, but guess what? It wasn't DEI that got me to college. It was a university by the sea known as the Savannah State University, the state's first historically black college or university in this state, where we started off in Athens, Georgia, and we were moved down to Savannah and given swampland, which happened to be the old placenta plantation. And they told our first president, well, maybe you can make the Georgia Industrial College for Negroes go down here. And he said, and I quote, "Tell them we are rising."
Thank you, Senator.
Recognize Senator from the 41st.
Thank you, Mr. President. Senator, do you yield?
I do yield.
Senator, I know there's a series of amendments on the table, so you may not have had a chance to look at it, but I want to look at amendment number 2 for a minute, and if you could just give me your opinion as to whether you would understand this to be a friendly amendment. Now, this amendment is from the senator from the 14th, but it says that nothing in this code shall be construed to prohibit a local education agency or post-secondary institution from promoting as an official position that, 1, evolutionary biology is a scientific fact. 2, slavery was the primary or major contributing cause of the American Civil War. Or 3, the Holocaust occurred. So in your opinion, dear Senator, would you consider that a friendly amendment for us to attest that we need to include these things when we talk about DEI?
Absolutely. I do believe that is a friendly amendment to my good friend, the senator from the 41st. And the reason I believe that to be a very good amendment, because when we talk about the need for states' rights, the idea that the Civil War would happen was an issue between the North and the South, because the South wanted to promulgate and maintain slavery as a status quo. And so I do believe that that is a scientific fact, that that did in fact happen. And in fact, President Lincoln, when he wrote his second inaugural address to Congress, said that the dogmas of the quiet past are inadequate to the stormy present. For our case, we must arise. The occasion is piled high with difficulty. For our case is new, we must act anew and think anew. And so as Lincoln was talking about that, his message was to unify the country around the idea that we ought to treat everybody the same. And that's why we have the Emancipation Proclamation. And it wasn't until about June, I believe, 1865, 66, when federal soldiers marched down to Galveston, Texas to free the last few slaves that remained in Galveston, Texas. And that's why we have Juneteenth today. And to also talk about the Holocaust, Senator, is also included, because we want to make sure that everyone's history is recorded, taught, and described properly, because when we talk about the anti-version of diversity, that is uniformity. And if you could think about what Jews suffered in the Holocaust, that was about uniformity to ensure their extermination. So therefore, Hitler did not want diversity, he wanted uniformity. That's why DEI is a slippery slope, and why we must caution ourselves before we entangle ourselves on a web that is further eroding.
Senator from the 51st, you have a question? You don't have a question? Okay. I got you, Senator. You're almost there. Recognize Senator from the 9th.
Senator, do you yield?
I do, to my good friend from the 9th.
Isn't it true that we're talking a lot of money, a lot of federal dollars, a lot of state dollars could be at risk for these schools. Is that not true?
That is true.
So I'm looking at the bill, Senator. Do you see anything in this bill where there's a process that can ensure complaints are evaluated fairly and the schools are going to be allowed to defend themselves? Do you see that anywhere in the bills?
Senator, I do not see that in this bill. What I do see are punitive measures, and I don't see how those punitive measures will be even interpreted because the measures are simply that state funding will be withheld, and I, Senator, wonder who will be the person to make the determination on the application of such legislation or its enforcement, because I'm too wondering how would that go, or would that just be the thought or idea that DEI is happening and then funds would be withheld, and would that be the power of the General Assembly, which also brings another question that is unconstitutional, because when the General Assembly appropriates money to the University System of Georgia, we do so in a block grant, Senator, and so that money is then appropriated, and it's up to the University System of Georgia to determine the administration of those dollars that are appropriated by the General Assembly, and we do not have the power to choose what money goes to what institution outside of the capital outlay, and I'm certain that the senator from the 19th would agree with me in terms of that process. So even to talk about the withholding of funding, it is my opinion, Senator, that that too would also be considered unconstitutional, because the state constitution says that whatever money we promulgate to the university system, it is up to the system to then administer and distribute out as they see fit.
Senator, do you further yield?
I further yield.
So to be clear, there is nothing in this bill to where an institution could properly defend themselves against this law.
No, and that's my concern, Senator, about the legislation. And so the other concern that I have about the legislation talks about the State Board of Education shall be authorized to withhold for a local education agency. But as you know, we've made it rain on vouchers, and nothing in this bill will prohibit private schools from teaching any curriculum that would be considered anti-DEI. And so you could have very much so a school that chose to be very racist in its nature and to promulgate hate and use state dollars to do that, because we've allowed you to take a voucher and go and do that. And so my colleagues may disagree with that, but I do believe that that would be an issue, because if I had a private school and I accepted vouchers and I wanted to teach critical race theory, there was nothing in the law that would prohibit me as a private school to do that. This only applies to public schools.
Recognize Senator from the 44th.
Thank you, Mr. President. Senator, do you yield?
I yield to my good friend.
Senator, we've been talking some in this debate about merit and the relative merit of people admitted to universities, given certain opportunities, and appointed to certain positions. Now, isn't that true?
That is true.
Right. Now I'm on Education and Youth Committee. You are not, but I know you're familiar with this debate from what's already been going on here on the floor. And accept as the premise of my question that the relative merit of individuals in jobs, not just in universities, is also part of this conversation. I want to ask you, Senator, about your views on the resumes of two of our top officials in the Department of Defense. I'm going to start with our former chairman of the Joint Chiefs of Staff, Charles Q. Brown Jr., also known as CQ Brown. I also want to ask you about the current Secretary of Defense. His name is Pete Hegseth. First, Senator, I'm just going to give you a snippet of each of their resumes, and then I really want to get your thoughts on relative merit and DEI. Charles Q. Brown was the 22nd Chief of Staff of the U.S. Air Force. He was a ROTC at Texas Tech. He served in a variety of positions at the squadron and wing levels, including an assignment to the U.S. Air Force Weapons School as an F-16 Fighting Falcon instructor. His notable staff tours include aide-de-camp to the Chief of Staff of the Air Force and Director of the Secretary of the Air Force and Chief of Staff Executive Action Group. His joint assignments include 3 assignments to U.S. Central Command as Air Operations Officer, Current Operations Division, Deputy Director, Operations Directorate, and Deputy Commander. He has commanded a fighter squadron, the U.S. Air Force Weapons School, 2 fighter wings, and twice served as a combined Joint Air Component Commander with command tours at U.S. Air Force's Central Command and Pacific Air Forces. General Brown is also a command pilot with more than 3,100 flight hours, primarily in the F-16, including 130 combat tours, and has flown 20 additional fixed and rotary wing aircraft. He deployed or directly supported Operation Southern Watch, Operation Northern Watch, Operation Enduring Freedom, Operation Odyssey Dawn, Operation Unified Protector, and Operation Inherent Resolve. And I could go on and on. Let's turn, if you'll indulge me, to Pete Hegseth, Secretary Hegseth, and let me just tell you that these are both from the Department of Defense website, same website. He was commissioned as an infantry officer in the U.S. Army National Guard. He participated in a number of active duty deployments, including at Guantanamo, Iraq, and Afghanistan. He has authored 5 books, and he has gotten several military awards. Those are the 2 biographies. Senator, can you let me know who you think was qualified to be in charge of our troops who are putting their lives on the line? And give me your thoughts on the relative merit of the people appointed to be cabinet secretaries in the Trump administration.
Well, thank you, Senator. That's a really good question. If it was based actually on merit, as you know, General Brown has a commensurate resume and combat experience that is unparalleled to anyone else. And so to the current Secretary of Defense, he does not have the resume that is compared to General C.Q. Brown, and neither has he reached the rank of general, meaning he did not serve enough time. He did not receive more time and grade or promotions to receive or have a higher rank than General Brown. General Brown absolutely is commensurate with, based on merit, the more qualified candidate based on merit. And for those reasons, that's why, again, merit is determined based on the person who determines what the merit is. There's no rubric or rigorous litmus test as to the determination of what is merit and what is not merit. Merit is decided by the person who is reading the resume and application that makes the determination on who has what merit.
Senator, is it not true that Secretary Hegseth himself insinuated or directly said that C.Q. Brown was a DEI hire?
Absolutely. I did hear that statement, and I heard that statement multiple times. And in fact, General C.Q. Brown, as chairman of the Joint Chief of Staff, and his current replacement lacks even the rank that General C.Q. Brown. He's a vice general, not even a 4-star general, and he only has intelligence experience and does not even have combat experience, which was required for the job, and therefore would require a waiver to even serve in the position because he didn't have the relevant experience. And so when we talk about merit, again, merit is in the eye of the person determining what is merit and what is not merit, which again further erodes an issue of why you have to have diversity, equity, and inclusion, because as someone who is a member of the minority party and a minority in the minority party, you have to talk about representation and what does that look like when you are a minority and you're not in the majority, and if the majority makes all the decisions and those who are in the majority don't look like anyone else and choose to only put people who look like them into positions, then that's an issue. And if you look at the current administration's cabinet, you only find 1 African American in the cabinet, and I'm sure there are more African American conservatives that exist. And furthermore, Senator, if the current president would have appointed out of the 3 Supreme Court justices, he could have added another African American if he chose to do so, but that would require the intentionality that is diversity, equity, and inclusion to ensure that the courts are reflective of a country that we all love and live in.
Senator, are you aware of the fact that an individual who was in both Trump administrations posted on social media that you have to have qualified white men running everything?
I am very familiar with that statement, and I did read that statement. And if any of my colleagues did not read that statement, I would be glad to photocopy that, Senator, and place it on their desk, which again is why diversity, equity, and inclusion exists, to ensure that you have a well-represented, thought-out idea, because everyone of diverse backgrounds, ideas, have different opinions, they have different thoughts, they have different lived experiences, and I cannot tell you what my lived experience is versus your lived experience, but I can tell you that you don't know what it's like to be last if you've always been first.
Senator, You were here in the Senate when we passed in 2022 HB 1084, were you not?
I was.
Senator, that you referenced it in your remarks earlier when you discussed the debacle on AP African American Studies.
That is correct.
Senator, why are we, in light of that debacle and the fact that we already passed this law 2 years ago, wasting everyone's time on this exact same topic? What are your thoughts on that? Why are we doing that?
Well, Senator, considering that it is late in the midnight hour and we're bringing this bill up, further erodes public trust, in my opinion, of what the General Assembly is here to do. We've debated a myriad of bills. We debated Brunswick stew. We debated cornbread. And now we're talking about banning diversity, equity, and inclusion among a chamber that is quite diverse. And so, Senator, it is a great travesty to the state of Georgia and to the American people that we're debating such a measure at such a late night hour, but I'm invigorated by my foremothers and forefathers that I will yield the well because I may have questions for other senators as well.
Thank you.
Thank you, Senator. Recognize the Majority Leader.
Mr. President, motion to resolve debate.
That is in order. Senator from the 41st.
I move that we table this bill.
That motion is in order. And it is a higher precedent than the Majority Leader. So the lady's motion to table from the 41st, all those, anybody object to that, I'm sure? Okay, you object to that. All those in favor of the motion to table will vote yea. All opposed, no. Secretary, unlock the machine. All right, on the motion to table, the yeas are 21 and the nays are 33, so that motion has failed. Senator from the 14th, for what purpose do you rise?
Mr. President, I move that this Senate stand adjourned until 10 a.m. Friday, April 4th.
Well, that motion is in order, Senator, so is there objection to his motion? We have objection. On the motion to adjourn from the Senator from the 14th, we have objection from the Senator from the 29th. On the motion to adjourn, those in favor will vote yea. Those opposed, nay. Secretary, unlock the machine. On the motion to adjourn, the yeas are 21 and the nays are 33, so this motion fails. Senator from the 41st, what purpose you
Mr.
rise?
President, point of order. I'd ask for the ruling from you, Mr. President, on the germaneness of this bill in light of the fact that it was fully stripped and replaced with another bill. I do believe that we have a subject issue as it relates to the underlying bill, and so I ask for your ruling on this bill as it pertains to its germaneness.
All right. Senator, you want to go back to or you can take it. You can find out what my germaneness is right now. Senator, the chair rules that it is germane. It is in Title 20 under the Education and Youth, and it is common that these subject matters get integrated into different bills from the House to the Senate. I'm sure you have an objection to that, I'm sure.
Mr. President, I would like to appeal the ruling of the chair.
I figured you'd want to do that.
Thank you, Mr. President.
Let's do that. She has the right to do that. So the good senator from the 41st has appealed the ruling of the chair. All those in favor of her question is, should the ruling of the chair be sustained? All those in favor will vote yea. All those opposed, no. Secretary, unlock the machine. Senator for the 41st, what purpose
Parliamentary
you rise?
inquiry.
State your inquiry.
Isn't it true that the underlying bill was about pay, sick leave for teachers, and the very author of the bill didn't even appreciate having this stripped out? Isn't that true?
Oh, this time of year, there's no legislator that appreciates their bills being stripped.
That's fair.
It takes 29 red votes to turn the chair. The yeas are 33 and the nays are 22, and the motion fails. Now we're back to the majority leader's original. Senator, you're out of motions now. Y'all have exhausted all of them. Actually, you might have one more. Let's see if you do it. Here we go.
Am I recognized? Yes, I'd like to make a motion. Mr. President, in light of the lateness of the hour and the fact that we're going to be here in just a day until even later than this, we're all exhausted. The staff is being held hostage. I would like to move under Senate Rule 6-1.2 that we lay this bill on the table and all go have a drink together, Mr. President.
We've already had that motion.
It's a renewable motion.
But I'm glad you said that, Senator, because we have one young lady, Paige, that's still with us right now, that we need to recognize, Miss Emma Tyson here. Let's recognize Miss Emma. Senator, right now it's not the appropriate time for that motion, but you may bring it up in further on in debate if it goes much longer. So now we're back to the majority leader's motion. Majority leader, would you hold on one second, Senator. Would you make that motion again?
Mr. President, I move motion to resolve debate.
Is there objection? There is objection, so all those in favor of the motion hold on one second, Senator. On the motion to resolve debate, all those in favor will vote yea, all opposed nay. Secretary unlock the machine. Now, Senator from the 10th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that we have well over 20 amendments to this bill, and trying to dissolve debate would not give those that we represent, our constituency, an opportunity to
That's not
voice
true, Senator.
that question?
It's not true, Senator. Those folks are going to have an opportunity to speak to their amendments.
Thank you, Mr. President.
On the motion, the yeas are 33 and the nays are 22, and the motion prevails. So the posture of it, where we are right now with that motion to resolve, there will be 3 more speakers that will be allowed, and then everyone who's presented an amendment will have 2 minutes to present that amendment. Recognize Senator from the 19th.
Mr. President, I ask for a ruling by the chair pursuant to Rule 7-1.6D. We have now, I think, 20 plus amendments. I think that they've been offered in the nature of a substitute for the purpose of circumventing paragraph B of the same rule, and ask for a determination by the chair of whether or not that would be out of order.
I believe, Senator from the 19th, I believe that you have made a compelling argument, and I believe that we shall call each one amendment that is trying to definitely circumvent the nature of the underlying bill, and to save us time and effort. I think that you'll rule in your favor if you're favoring, consider them out of order. Hold on. Senators from the 41st.
Mr. President, we appeal the ruling of the chair.
You can do that. It's in order. So she's appealed the ruling of the chair. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the vote, the yeas are 33 and the nays are 22, and the ruling of the chair has been sustained. I recognize the senator from the 23rd to close debate. Senator from the second, state your order.
Mr. President, I move for reconsideration of the resolution to end debate. I move for reconsideration of the resolution to resolve debate.
Reconsideration of the motion to resolve debate. That motion is in order.
We've had intervening motions.
All those in favor of reconsideration of the majority leader's motion will vote yea. All opposed, nay. Secretary, unlock the machine. Senator for the 55th.
President, is it the intention of the president to at least read the amendments? Because I know the amendment that I had has nothing to do with what the distinguished gentleman motion. I would like to at least know what the amendments are. At least let the light of democracy have some daylight in this august body. At least read what the amendments are.
Senator, you have the amendments on your desk, and the chair's already ruled on the amendments. On the motion to reconsider, the yeas are 22 and the nays are 33. The motion has failed. So I recognize the senator from the 23rd to close debate. Senator from the 23rd, recognize you to close debate. So the senator from the 23rd, the senator from the 22nd has a minority report, so we'll recognize the minority report first, and then we'll let you close debate. Recognize senator from the 22nd. There's the amendment. There's no longer any amendments, Senator.
Thank you, Mr. President. Today will be a sad day in the Georgia Senate, without a doubt, in the history of this body. To close debate on such a motion, to close debate where we're talking about human rights here, the rights of people who have been subjugated to discrimination for over 500 years, mind you, in this particular nation and also in this particular state. One of the reasons why I believe this happened was because there were 3 amendments that I think were actually friendly amendments, quite frankly. One of them dealing with, all of them dealing with the history of African Americans within this particular country. Amendment number 2 talked about slavery was a major contributing cause to American Civil War. Amendment number 3 also talked about the Confederate States of America being a separate nation and one that was rebellious. And also Amendment number 6 talked about similar ideas, that the Confederate States was a separate nation and rebelled against the United States. And we maintain in this particular caucus that this body was afraid to address those particular amendments. And that's what actually closes this debate. And we would hope that they would actually open this, because when you start talking about that you believe in equality and fairness, then I think that those amendments were definitely friendly amendments. If someone comes in here and starts talking about they believe in equality and fairness, then you certainly cannot hold the values that represented the Confederacy of the states. You certainly cannot hold the values that represent slavery within this particular country. And these things would have spoke to that. These amendments would have spoke to that. And we know for a fact, no one can doubt, no one can ever doubt that this state and this nation and the Confederate States of America was founded on the concept of slavery. And that's what their persons were afraid of, because they knew they could not vote against that particular amendment. They knew the fact in Mississippi it says this in their Confederate state charter: our position is thoroughly identified within the institution of slavery, the greatest material interest of the world, its labor supplies, the product which constitutes by far the largest and most important portions of commerce on earth. That's the Mississippi succession of states. They knew for a fact they could never say that slavery was not a contributing factor, even though they know their crazy base would not want them to vote for that, because they know that Georgia, in their succession of states, said this: for the last 10 years, we have had numerous and serious causes of complaint against our non-slave holding Confederate states with reference to the subject of African slavery. So they understood exactly they could not vote against these amendments, but they couldn't vote for them. And so that's why they stopped this debate, because they were afraid of the truth of what Georgia actually represented over the last 100 years. They were afraid of the truth that the fact of the matter is the first African-American admitted to law school was in 1966. Africans have been in this state since 1526, 440 years. And the first African-American ever admitted to law school was 440 years later. And we're sitting up here talking about some silly DEI kind of programs where state-sponsored discrimination, state law, stop persons from gaining access to these schools. And you're concerned and want to equate some type of DEI program that maybe makes somebody feel uncomfortable with real discrimination, real policies that affected African Americans. The first African American mayor in Augusta, elected in 1980, 450 years for the first time African Americans were brought here. The first medical student admitted to medical school in Georgia, 437 years after the first African was brought to Georgia. And then persons dare say that anybody that survived that, any descendant that survived that is unqualified. I will tell you that any descendant that survived that is the most qualified person in this room, the most qualified person in this state, and have the audacity to actually talk about persons who have overcome state-sponsored discrimination for 450 years. And to say that those people on any level is unqualified to do anything. And that because there may be some program that maybe makes somebody feel uncomfortable in a classroom, you're going to actually deprive persons again. This is a sad day. Make no mistake. This is one of the worst days in the Georgia Senate history. We were prepared to fight this bill all night. This caucus runs from nothing and would never run from anything. When it comes to the human rights of our people, we're going to fight. And we were prepared to fight all night. We're sorry that you were not prepared to defend your positions as you once again are going backwards as far as race relations in this country is concerned. With that, I yield the well.
Senator from the 23rd, you may now close debate.
Thank you, Mr. President. I appreciate the passion. I appreciate the struggle. Senator from the 26th, I grew up in the 60s, in the 50s and the 60s. I grew up in the segregated South. I grew up in a school that had no black students until I was in high school. Was that wrong? Absolutely, that was wrong. In 1860, this nation was a far cry backwards. Have we made progress? We have. Is it sufficient? It is not. I lived through the civil rights movement. I remember going over on Boulevard to pick up a date at Georgia Baptist Hospital in the late 1960s, and there were riots in the street. And the reason there were riots in the street is because people were being oppressed. They deserved the opportunity to express their positions. DEI is the antithesis of equality. If you believe in equality, if you believe in equal opportunity, this bill does not strip you of that. It enhances it. If you believe that discrimination in any form is wrong, then this legislation aligns with making sure discrimination does not happen in any form. If you believe that academic admission should be based upon objective measures and not on personal traits, then this bill supports that. The same is true for employment or promotion or assessments of assignments. Equality means everyone can have an equal opportunity to be successful. That no one is given special considerations or special benefits associated because of their race, their color, their ethnicity, or any of those protected traits. This is a tough issue. I recognize that. But I stand here today to assure you that this is not an attack. This is an opportunity for us to ensure that everyone is given non-discriminatory access to education in Georgia. Thank you, Mr. President. I ask for your favorable consideration of House Bill 127, and I yield the well.
The Senator has yielded, and the previous question has been ordered. Senator from the 44th, what purpose you rise?
Motion. Thank you, Mr. President. Mr. President, these amendments have all been ruled out of order, which is really a shame because there's actually a glaring error in HB 127 because you see, Mr. President, in attempting to ban DEI, HB 127 actually bans the banning of DEI. And if we had been able to pick up Amendment 7, we could have fixed that glaring error. But since they were ruled out of order, at this point, there's nothing left but to make a motion to table this erroneous, error-ridden legislation. So I move to table HB 127.
Okay, Senator has moved to table. I'll recognize it to be in order. Those in favor of her tabling the bill will vote yea. Those opposed, nay. Secretary will unlock the machine. On the motion's table, the yeas are 22 and the nays are 33, and so that motion has failed. So the previous question has been ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. Senator, for what purpose do you rise?
Isn't this bill no less than a high-tech lynching that they did when they did not want us to pass the same law that it took 14 years to pass, and now we're going to take it away tonight here in this chamber?
Senator can vote yea or nay on the issue.
Y'all know it's right. Thank you.
On the passage of the bill, the yeas are 33 and the nays are 21. And this bill, having received the requisite constitutional majority, is therefore passed by substitute. Senator from the 41st, what purpose you? Senators move that we reconsider. Senator, you have 3 minutes. Would you wish to speak to your 3 minutes?
Thank you, Mr. President. I rise to invite our colleagues here to reconsider this vote. There are a number of reasons that have been articulated in 20 amendments on your desk. But I also just want to highlight for what we're doing tonight. Tonight, if we were to pass this bill, as you all have already strived to do, we're making a statement about who Georgia is and about what we value and don't value. And fundamentally, if we vote to ban diversity, equity, and inclusion, we are saying that we don't value the diversity of this great state. So many of you represent beautiful, amazing, diverse people across your districts. We talk on a regular basis about things that are very gender specific. If we were to ban this, how would we stand in this well and talk about maternal health and making sure that we take care of women? That's a gendered issue. We've worked tirelessly in this body to fight against human trafficking, a gendered issue where we raise the issue of gender, and yet we're telling our colleges and universities that they can't do any training that references gender specifically. My friends, if we believe and value diversity, then we can't vote for this bill a second time. If we value inclusion, which this very body represents, and I believe we actually do, then I am inviting you to reconsider this so that you can vote no. And the fact is, equity matters. Equity is what has made it possible for so many of the African Americans in this room to be able to stand up and fight today in the way that we have fought. And so, friends, I invite you to reconsider your position and at the very least allow my brother from the 38th to have a chance to cast his ballot once more. With that, I'll yield the well.
Thank you, Senator. Senator has moved that we reconsider. Is there objection to that motion? Well, say it. Okay. Senator, from Majority Leader, would you like to speak? Use your 3 minutes? You waive your 3 minutes? Okay. So the Senator from the 41st has moved from reconsideration to reconsider. Senator, the Majority Leader has so here, we'll just put it on the board. All those in favor of the motion to reconsider will vote yea. All those opposed, nay. Secretary, unlock the machine. On the motion to reconsider, the yeas are 22 and the nays are 33, and this motion has failed. Senator from the 55th, what purpose do you rise?
Pursuant to Rule 8.113, I would like to enter into the journal a protest in writing against the actions of this honorable Senate and ask that this presiding officer indicate the timing in which that would be appropriate.
Senator can deliver that anytime between now and Friday morning to the secretaries. Recognize Majority Leader.
Mr. President, I ask for unanimous consent that House Bill 399 be taken from the table.
Senator has asked for unanimous consent that House Bill 399 be taken from the table. Secretary, read the caption.
House Bill 399 by Representative Oliver of the 84th and others, a bill to amend title and act to amend Article 1 of Chapter 7, Title 44 of the Official Code of Georgia annotated related to landlords and tenants in general, so as to require certain residential landlords to have in-staff to manage tenant communications related to such property, to provide for related matters, for bill and looking laws, and for other purposes. Mr. President, that completes the order.
Table 399. Mr. President, I move that we table House Bill 399.
Is there objection? All right. Would you like to speak to the motion? No. Recognize Senator from the 6th.
Parliamentary inquiry, Mr.
State your
President.
inquiry.
Is it not true that in order for a bill to be available on day 40, it must be tabled today? Therefore, anything on the table to be eligible on day 40 must be taken off the table today and then put back on the table.
That is correct. Senator knows what he speaks. All right, we have an objection from Senator from the 35th. All those in favor of his objection will vote yea. All opposed, nay. You withdrawing it? All right, so now the senator is withdrawing it. Secretary, read the caption.
House Bill 399 by Representative Oliver of the 84th and others, a bill to amend title and act to amend Article 1 of Chapter 7, Title 44 of the Official Code of Georgia annotated related to landlords and tenants in general, so as to require certain residential landlords that have in-staff state to acquire to manage tenant communications related to such property, to provide for related matters, for bills and looking laws, and for other purposes. Mr. President, that completes the order.
399 has been put on the table.
What's that?
Recognize Majority Leader again.
Mr. President, I ask for unanimous consent that House Bill 172 be taken from the table.
Secretary, read the caption.
House Bill 172 by Representative Huddleston of the 72nd and others, a bill to be entitled an act to amend Part 6A of Article 7, Chapter 3 of Title 20 of the OCGA related to state veterinary education, so as to provide for the limits of the student loan forgiveness program, to provide for related matters, for bills and looking laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, 172 is put on the table. Well, make the motion. Taken from the table.
Mr. President, I move that House Bill 172 be tabled at this time.
Is there objection? That objection is tabled. Recognize the Majority Leader for another motion.
Mr. President, I move that the Senate stand adjourned until 10 a.m. on Friday, April 4th.
Secretary, read the announcements.
Mr. President, there are no announcements.
All right, so the Majority Leader has moved that the Senate stand adjourned until 10 a.m. Friday morning, April 4th. All those in favor signify by saying aye. All those opposed, no. Ayes clearly have it. We're adjourned. See you Friday.